you see? Creativity flowing, you're blocking the spree. Press the stop button, move on today. Don't ruin the magic with the words you say. Silence all the noise, let your mind be free. Turn the sound up, keep the melody. You call it critique, but it's stale charade. In the harmony of life, you're the dissonant parade. Can't you hear the music, the rhythm up ahead? Leave behind complaints, join the dance instead. Crank the volume high, let those doubts fade. We'll paint the town with colors and notes we cascade. Blocking the spree. Press the stop button, move on today. Don't ruin the magic with the words you say. Silence all the noise, let your mind be free. Turn the sound up, keep the melody. Oh, the pity parade, marching without grace. Stuck on repeat in the same tired place. Click the remote, change the channel's tune. Life's too short, let's skip to the next afternoon. So pack up your tales of woe, let them drift away. Catalyze the spark, don't kill the display. Fine, say goodbye to the moans, let's hear a brighter sound. Lift the spirits high, creativity abound. Oh, your symphony of sighs won't bring us down. In this technicolor world, we're painting the town. Give your grievances a break, let laughter fill the air.
Hello everybody. Let's go back here. How are we all? Oh, all my favourites in the chatters today. Hi Shaylin, how are you? Red, Kev, Queen Olive. How are we all? Princey. Hello Nightbot. I see you decided to join us. Alright, so I thought we might just have a little rundown on how to go through the form, how to fill out the form, because I realised yesterday on Kurt's stream that it was probably a little more complex than I was thinking. So, let's get that on the screen. Hang on, I might need to go back to this one and share this screen. Hang on. There we go. I can close that one. Right. Oh, nice. Nightbot's doing all the right things today. Bloody awesome. All right. Yeah, this ended up being a little bit more complex than I was expecting. So I thought, maybe we should go through and uncomplex it a bit. Most people are getting it, but so just to make it entertaining, I thought instead of just reading through it all, because it is pretty boring just reading the SJC's rules, that we might actually look at the rule first and then look at some of the funny comments that you guys put in there. But, well, I wouldn't say they were all funny, but most of them were, just honest comments. So I thought that might be the way to go about this, so it was like a little less boring. So I'm going to flip between two screens. So we would start here with reading that, how the SJC writes it. So the types of things that would be giving precedence to the duties of judicial office might include blah, blah, blah in Rule 3.7 and Cannone 3. And that's just a little bit too complex for everybody. So I have hay fever chronic again today. My ears are itchy, my nose is itchy, I'm phlegmy, so you'll have to excuse the hay fever. It's take the pills for hay fever or suffer through it, and so most days I like to suffer through it. I don't like to be on any pills, so I'm not one to give the chemist companies a good rap. Let's say that. Hello, digital artist Lee. Thanks for joining us. And Operation Double Scoop. Well, that's very suited to today's stream. Is it not? Faceplant Sundae. So, hi, Yelenetti. Carla. Michelle is in the house, everybody. I'm sorry, I'm missing every time I click on something it moves, so I'm missing his. Thank you, Pee-wee Herman, for your Pee-wee Herman, for your membership. Nice to see you too. Carla, if I didn't say hello already, hello. It gets to a point where I've forgotten who I've said hello to. All right, so yeah, in question 1, let's switch to the other stream and see what some of the responses were. So I basically asked I uploaded the spreadsheet to ChatGPT and just asked it to isolate the things I wanted to read, because I don't want to give, anyone's details away or anything else that, that is outside the scope of what we're doing here. So one of the things to note is that I'm not collecting email addresses, but you do have to log in so that I can only get one response per person. That's how Google Sheets works, to narrow it down to one response. But I'm not collecting email addresses or anything like that, only just your scores and your comments. And so for question 2.1, we have some interesting comments. We have Bev hates the public, quits early and short weeks. Well, as far as her judicial duties go, I kind of feel like that's relevant, right? The duties of judicial office, as prescribed by law, shall take precedence over all of the judge's personal and extrajudicial activities. Well, having a full day is probably something I would say would take precedence, wouldn't you? That's a good start. Not hating on the public. I'm sure Judge Bev would completely block us out and have no cameras in there if she could. You didn't know what to do, Queen Olive. Well, that's what I'm here to do, to show you today. Give her a grade. So we're reading mine at the moment, and that was my comment. I gave her a grade F for Rule 2.1, and the reasons that I gave her that grade, essentially. So yeah, I probably did make it a little too complex for y'all. So what I was doing when I made this form was I was actually mapping someone else's mind. So that didn't make it easy. The mind I was mapping is let me see if I can get his for some reason his name's just jumped out of my head. I don't know why, but let me get his link so that Kevin can share that with you guys. Where are we? Yes, Carl Steinbeck it is. So just pop that up. Oops, you got it, Kevy? I probably should have you up here backstage so that you can hear me live. let me get Kevy up here backstage so he can do the chores in the background. Sending you a link, Kev, so you can hear me real time instead of a minute behind. A link to the stream. Yes, I'm going to. Here you go. It's in Discord. And Carl Steinbeck is who we're after. So well, Cannone actually see the survey? I don't know, Red. What I hope will happen is that locals will use it to their advantage and submit it somewhere. I don't know that we get a lot of say as international viewers or an international audience. I do know that international does make a bit of a splash at SCOTUS level. So they look at, the thing that I've been emphasizing all along: justice has to be seen to be done in order for it to be done. So if we don't feel it's been done, well, if the people who are in that electorate that the state supposedly represents don't see it to be done, then it's not done, obviously. So, okay, I've got Kevin backstage. So let me just pop him up for a quick intro. Unless you don't want to say it, nod yes or no. I'm looking for Carl Steinbeck. The video he just did where he graded Judge Bev. All right, he's going to go look for that. I don't know that he actually wants to be on screen. So, all right, so yeah, and pop that link into the chat, and I'll try to pin it. I think I can pin it from here for you. We'd be looking fly with the feds watching. Right. Well, who knows? But yeah, essentially, I just want everyone to feel like they were participating in Carl Steinbeck's idea. It was a great idea. I love to model what people are thinking into, an app or a series of apps as I've done here. Like, I wasn't going to write this code from scratch. I don't have time for that. Thank you, Kevin. And so, yeah, I just basically decided, let me just pin this. So there's Carl Steinbeck's idea. That's him going through the Judicial Code of Conduct, explaining to you what each of the points actually mean. Now, if you like to have a more thorough, less jargonized, what is it? Less rhetorical explanation, like more closer to the law, you can go and check out the stream that I just did with Kurt. Because he does actually do it in a much more black and white, this is how the law reads fashion, whereas Carl Steinbeck's kind of more on our level, like speaking to Englisher, if that makes sense. I really do enjoy Kurt's legal breakdowns and the way that he describes things legally. So each has their place, I guess. It depends on how you prefer to hear it. So I understood both. Carl's is at the top since it was his idea that I flogged, so to speak. Anyway, so for question 1.1, those were the things that I listed. Bev hates the public. She's got that great big, perimeter that no one's allowed in, and she's using force to enforce it. Someone's already being represented by the DUI guy, Larry Foreman, for being attacked by the police for just asking questions like, what's this about? Why, what am I supposed to do? What are you telling me? He got he got arrested, roughly. So yeah, that was the reason I felt that Bev was failing her judicial duties outside of personal extrajudicial activities. I felt that she was absolutely not respecting the public, not respecting journalists that are not mainstream media, and so on. But other people gave it different reasons. Someone just said plain old F, and what plain old F means is, if I show you this spreadsheet, this is what I sort of pasted on there so that you could give a reason for, if you couldn't think of a reason that you gave it. This basically says, here's the reasons. If you gave an A, it's like the robe fits. So impartial, professional, and actually follows the SJC rulebook. Might be the only person in the room who reads it. So B for will allow it. I think I might have changed these gradings actually on the final screen, but we'll see. I'll come to that in a minute. But anyway, F is what I gave her. It's fine as a new judge. The SJC rules were last seen sobbing in the gallery. A procedural dumpster fire. Disbar the vibe and reboot the system. So those are the types of replies that you could choose. So anyway, Kevin, you might want to post Kurt's link in the chat at some stage as well, because we did do that show yesterday. I do have Carl's pinned just because it was his idea that I flogged. Thank you, buddy. So, all right, works much better real time, doesn't it, Kev? Then you're waiting like a whole minute to hear my question. All right, so did I end up flipping the right screen up? I did. So the other comments. Okay, a better link. Oh, did he cut it down, did he? Hang on. Let me go over to this side. Let me unpin that. And then pin that. There you go. Oh, you reworded it so it was more clear what the link is. Gotcha. All right. So so other people wrote, there is no F for rule 2.1. We're still on. Someone gave her an A, and I can dob him in. I actually know because I filled this out with him. This was Kurt's response. He said there is no evidence of personal or extrajudicial activities that create a conflict. So I felt that in the specific context of creating a conflict, I kind of felt that was being a little bit too to the letter of the law. But it does say in the question, as prescribed by law, her duties of judicial office as prescribed by law. So Kurt was being very, by the letter of the law with his response. Okay, someone else gave her F, give us a new judge. Someone else gave her a score of A. I haven't seen her break this rule from what I understand of this rule. So people can have different understandings of the rules. It doesn't matter how you respond or how you read the rules. So the object here is the grading system. So if you're looking at this like, a school report card, I scored it the same way we do for school report cards, essentially, because I was being sarcastic. Because Beb's the face plant that keeps on giving. So it doesn't matter how you read them or how you fill it out. Just put your thoughts down. If the section feels like it fits what you were thinking, put it in there. We don't need to be to the letter of the law here. So someone else gave her a score of E, should have recused herself for conflict. So in regards to that one, like we all know what that means. She's got personal relationships with the McAlberts, which she denies. But we've seen evidence of. We've seen, Venmo receipts of her renting out her seaside cottage to them, and her brother represented Chris Albert in a hit and run and pretty much got away with it, stuff like that. So that's what that's referring to. Someone else gave her a rule of a grade of F when Auntie Bev, because a thing she should have disclosed her ties to the McAlberts and the McCabe's, she should have. To not recuse at this point is judicial misconduct and null and voids trial one's results. Completely concur with that person who wrote that. So, yay for you. Someone just gave it a plain C, and in my C's is can't spell concerning without Cannone. So, moving on. Rule 2.1, watcher. We're watching. Whoever wrote that, we're watching. We are truly watching. Total bias, bordering on corruption. She does the opposite of 2. What was 2 again? She does the opposite of 2. Let me have a quick squeezy what 2 is. 2 is impartiality and fairness. She does the opposite of 2. There you go. Her bias to the so obvious and unfair. F. D, she has no interest in transparency. So a lot of people were like, you know what, I don't get the rules, I'm just writing my comments in, and that's okay. We'll take any of the comments you got. I don't think we're going to be using the comments so much as anything else except to commiserate with each other. Are we commiserating? Or are we in agreement or whatever? So it just gives you that validation. So that's where I was with that rule by the law, eh? By the law. Right. Yeah, but she's kind of mixing her judicial duties with her extracurricular activities, kind of. So, because there's other things here that we're not taking into account too. One of the things that we haven't actually found evidence of, but I suspect is going to come out eventually, is that she has had ex parte communications with D.A. Morrissey. That's why she appointed Brennan to be the taint team. That's actually a violation of due process, incidentally. Another violation of due process. I got a whole freaking list of them. So, C, rule 2, we're still on 2.1. No opinion either way. She's got a middle of the grade there. A most biased judge ever. Suspect favoritism as evidenced by her sketchy favoritism, protection of prosecution witnesses and rulings, etc. Bias, poor understanding of basic rules of court. And here's the thing. She actually has a good understanding. She's in this role where she's making rules for the court. She actually has a very good solid understanding, or she wouldn't have made it into that position where she's sitting on that board making rules. So I think it's selective. Pee Wee Herman, you don't know my name because I don't catch you anymore. Laurie, oh, I know who you are, Laurie. All right, that's our time zones. So it's a bit of a bugger there. Our time zones are a little mixed up. It depends what time I'm trying to be on. If I'm trying to be on American time, then I'm watching the court case all day, and I'm going live in at night for America. But if you're just going by my times, like now, it's like in the morning for me. I slept all night for a change. Then that's probably why you're missing me. So if Karen Read was actually found guilty, that verdict would easily be overturned. Everything's so overturned. It's so overturned so many times, it's not bloody funny. So midnight in Ireland for Kevy. Oh my God, we got you up late, mate. All right, so that's how people are grading Rule 2.1. So we don't need to read hundreds of Rule 2.1s. We'll just move on now to Rule 2.2. So let me go back over here to Rule 2.2. This one's talking about impartiality and fairness. A judge shall apply the law, and shall perform all duties of judicial office fairly and impartially. So Kurt is reading that in relation to what the comments are. And so I kind of get where he's coming from there when he relates it just to the comments. He's not finding anything where she's impartial or unfair. But I think I actually graded her a D for this one. But that's basically what they're saying. Impartiality and fairness. To ensure impartiality and fairness to all parties, a judge must be objective and open-minded. Although each judge comes to the bench with a unique background and personal philosophy, a judge must interpret and apply the law without regard to whether the judge approves or disapproves of the law in question. What about the parties in question? When applying and interpreting the law, a judge sometimes may make good faith errors of fact or law. Errors of this kind do not violate this rule. In the absence of fraud, corrupt motive, or clear indication that the judge's conduct was in bad faith or otherwise violates this code, it is not a violation for a judge to make findings of fact, reach legal conclusions, or apply the law as the judge understands it. I have seen her make several misinterpretations, and I believe it is in bad faith. But it's really hard to prove that, right? How do you prove that she misinterpreted? So many of them were misinterpreted in, what do you call it? Her ruling on the motion to dismiss, for example. Like, there was outright misinterpretations there. Would the SJC excuse her for that? Like, there was a couple of them in the exact same ruling. How do you prove that she's got bad faith, right? And then it comes down to something I've been talking about for quite some time, and that is the culmination of errors that she makes. When you look at every ruling she's made against the defense, there's a misquoting of the law in all of them. There's a bias in all of them. So then you end up with this cumulative effect. So that's how you would prove it, but it is pretty hard to prove. So you come back to rule point 2. My response was, Bev hates the defense, rules unfairly, violates due process. And I only gave us like a short paragraph, a short answer, because I didn't want to have to read pages and pages of people's responses. If I gave you all the opportunity to write a novel, some of you would. But my violates would have been a novel. Violation, sorry, would have been an absolute novel to read. Kurt said her continuing hostility, he graded her a D for that. Her continuing hostility towards the defense is mind-blowing by a comparison to how she treats the prosecution. So he actually agrees with us on that score. Although I scored her much lower for it because it seems to be every time. This person also did, and that was F for give us a new judge. This person says she doesn't make accommodations for the defense, and I believe she doesn't follow the law for the defense except when it becomes an appellate issue. She is not open-minded to the defense either 80% of the time, which, I agree with that comment. I'd have graded her much lower than a D for it. F, definitely not impartial. F, the double standard favoring the prosecution, her comments about grave concerns with the defense team when Proctor and Jen McCabe and accomplices haven't been thoroughly investigated throughout the existence of this case, and their lies and their misdeeds, bloody rearranging the reports. I mean, it goes on and on, right? E for, I forgot what E was for again. E for ethics, meh. F for prosecution has all the leeway. Defense is constantly chastised, cut off, and disrespected. So we don't need to read through all of the rules, but hopefully you're getting a picture now of how people are grading and understanding the way I set the form out. Bias, prejudice, and harassment. So some people might have gone up here and done the bias in the impartiality and fairness. Bias actually refers to more specific types of bias. And so when we're talking about judicial bias, it is in fact separate to the type of bias you might see you might call impartiality or fairness. So under judicial bias, prejudice, and harassment, my main concern here is the harassment of the ARCA guys, because that is pure harassment and harassing the defense because they can't produce the information that the DOJ won't release. So that's harassment as well. But in the context of the comments here, it's only talking about racial and inclusion type harassment. So yeah, that probably is a little bit confusing, that one. And I included all the comments, I think, for that rule. I did, to be more clear about what it's actually talking about. So it's talking about slurs, demeaning nicknames, negative stereotyping, attempted humor based on stereotypes, threatening, intimidating, or hostile acts. See, I would say the threatening and intimidating is definitely happening with Miss Read from the judge. Is that funny, Miss Read? And things like that. So, right, and a literal verbal darts at the defense, but not at the prosecution. Exactly. Queen, I'm still hung up on the time she scolded Karen. Something, yeah. I've seen plenty of ill-behaved defendants or gallery witnesses even, but Bev just made a scene. Exactly. So everyone's interpreting these, differently according to how they're reading it, and I'm okay with that. I don't care how you interpret them. It was based on these rulings. Up to you how you interpret it and how you score it. I have absolutely no issue with that whatsoever. But to cut a long story short, let's have a look at the results. Where we are with the results. Share this tab. Oh, yeah, there we go. Let me just check you're all seeing what I'm seeing. Here's our results. So some of you did ask, why did your original poll only ask us about, 3 areas and not give us more options to say like where we come from? That's because all the polls on YouTube and X are really limited. We don't get much choices with those polls. That's why I created a form with Google Forms, because I get some choices on how I want to ask you the questions, what questions I want to ask you, what order I want to ask them in, and I even get some choices as what to do with the results. And this is one such example of what we can do with the results. So essentially what I'm doing here is I am grading the overall score. So we've got 27 people have voted internationally so far, and the average grade for everybody has been E so far. So E for everyone sees the problem but the judge. Up until yesterday, it was actually averaging at F. So some people came along yesterday and gave her a slightly higher grade than E. So here's what I do expect. I do expect some people from the anti side to come along and try and fill out the form. And they can. I won't stop them. But what this will prove is that they are in the minority. They may now, while we've only got, how many count? I think we've got 40. Let me just have a look at our numbers. Holy shit, we've got 90 responses so far. So, right now at just 90 responses, we're probably, let me refresh this page just to make sure we are looking at the latest results. There you go. There's a few more that have filled it out since I last refreshed that page, but they will be in the minority. They may think that they're like affecting this score, but we know from all the other polls, everything's polling around 90% that Karen Read's innocent and that Judge Bev is a moron. So, so yeah. Other US states, so outside of Massachusetts, everybody that's in the United States but not international, just other states, they're basically grading her an average of E. Everyone sees a problem but the judge. Massachusetts, who it impacts mostly, is giving them a so far grade of F, and that's that is very interesting that we're grading, the locals are grading her F now. And the rest of the world's being a little bit more fair. Maybe we've got worse judges. There are some parts of the world that do. So, but these are the ones that count. And that's why I wanted to separate them. So when the SJC is looking at it, the SJC is looking at who does the state represent? It's the people of Massachusetts. That's the people. When it's the state versus Karen Read, it's the people that they represent. And that's their first concern. How do the people of Massachusetts feel justice is being done? And then SCOTUS will look at other states. How do other states view justice being done in Massachusetts? Those are the two main concerns that SCOTUS will see whether or not there's enough public demand for them to look at an issue. So we probably should have jumped on this way earlier than we did, because SCOTUS has already refused Karen's first certiorari, but that doesn't mean she's restricted. She can't do any other certiorari. She's got like a dozen of them here that she could do. But what we're doing, I think, as a strategy by the defense is waiting for, at least waiting for conviction, because we're going to need all of these arrows in our quivers if we're going to overturn a conviction. So we're not jumping into, you know, everything we've got in our quiver right now. And because trial 1.0 didn't necessarily result in a conviction, that closed a few doors as to what they can appeal. You've got to have the conviction to do the appeal part. So as I say, convictions for losers. Appeals is for losers. So, and anyway, international SCOTUS does take into account international, how you look on the international stage. But these are their primary concerns. This one first and utmost, because the state represents the people of Massachusetts. So, but international, you can even have in a certiorari, you can have international amici briefs, basically. And SCOTUS will take them in, even though they're not part of the country. SCOTUS will take them in as that additional information of how the world is seeing, you know, United States perform on the judicial stage, on the justice stage. So, all right, let me go back here and go through some of your comments now, because I've missed a lot. Hanky, objection. Bev, sustained. Defense, objection. Bev, overruled, or I'll allow that. I know the other day she was like, I think it was like one of the defense objected, and she was like, overruled, and then she called a sidebar, and that sidebar actually indicated that she was sustained. So Hank's head shake to her from Dr. Wolf interrogation was flipping obvious. I don't know what he was signaling to her, but when you're saying ex parte communication, that's not ex parte because it's in front of the parties. So if they wanted to raise it, they could have. But it's very hard to prove what he was doing there. Like, what are they going to do to prove, to raise it right then and there? They're going to prove that he just did that. That him and the judge can just deny it. She can deny she saw it. He can deny he did it. How do they prove it? They can't get the pool camera to roll it back. And they're not getting the transcripts of head nods, are they? So it's very hard to prove, but it's definitely obvious. The fix has been in since before John took his last breath. The corporate world is now involved in the corruption, and no one will be charged for their crimes. I think people will be charged for their crimes. They're just not going to be charged for murder. I'll go through that in a minute, because there are still charges that can come from this. But I'll go through it shortly. So, Chuck says, that's another thing. Bev throws verbal and literal darts at the defense, but not. Oh, yeah, we read that one. Gotcha, Chuck. I'm still hung up on the time she scolded Karen. Okay, I went too far back in the comments, didn't I? Karen's only crime was contempt of corruption, of corrupt Canton. Right. So, who you calling a bloody foreigner, mate? Mate. Deserving across the board, Queen says. 27 foreigners. The foreigners count expats too, though. Like Chuck and I from the Commonwealth of Pennsylvania. That's true. That is true. We have no court access, so we don't know. True, Hills Bills, true. To anyone I haven't said hello to yet, I'm putting your comments up on the stream because I've forgotten who I haven't said hello to yet. So I can tell you Atlanta has some pretty bad judges and prosecutors. Interesting. Good job, Kev. If you want to know more about filing a judicial complaint, you can do so here. I would strongly recommend that you be locals, like in Massachusetts at least. If you're going to do that, there's a different way for outside of the US and international to have this seen, and that's why I'm doing this exercise so that people can see. If SJC comes up with like, well, how do we know that the rest of the world is upset with the way this is going? Well, that's the point of the scorecard. We can show them this if we want to. People who are in Massachusetts and who do fill out that form on the MassGov website can actually link this to how ridiculous you're looking. So I would be including that in my complaint as to how embarrassing it is for you as the people of the state to have the rest of the world looking at this in the fashion that we're looking at it. So Operation Double Scoop says, to be honest, I'm not sure it was anything nefarious. I think it was Hank giving a tiny tantrum and Bev ignoring him and his silly shake. Could have been. Worldwide corruption, sadly, yes. Worldwide corruption indeed. You didn't have court access in Philadelphia either. You had to go sit in the courtroom. I don't know about since 2012 when I left that corrupt city. Well, that's how it is in Australia. Media is allowed to sit in the courtroom and write notes, and then they come out of the courtroom and then they do a news segment from their notes or whatever. They're not allowed. We don't have pool cameras and audio shit like that here in Australia. But the public gallery is open to anyone, including the media. But you can't take cameras. You can't record nothing. There's big fines in Australia if we're recording from a courtroom, apparently. So, because we also have a problem with self-sits doing shit over here as well. And I think they spoiled a lot of our privileges, created new laws that, prevented them from doing stuff in court. But anyway, so back to this. So down here we got like a chart, and you can switch to mobile view if you're looking at this on a mobile, which is really just, it's the skinny version for mobile, essentially. But let's go back to desktop because I want it up on the screen like this. So I just did the color chart, from green. This particular app that I'm using here is really freaking difficult and hard to understand, and it's not basic statistics. I don't know what the hell. Google, what the hell? It's very hard. But anyway, I got it working eventually. So just looking at, the chart here this is called a heat map, from green, from cold through to hot. And hot is your F score, like everything's too hot. So as you can see here, we've got 48 scores for F, 66 votes for F, 74 votes for F, 62 votes for F. That's for each of the rules, obviously, down here. So this is why I say, the antis can come and fill out the form, but look at the impact that they're really having here. It's very minimal impact. We're still overarching Fs all the way. So, and some people are even being a little lenient in the orange, which is the D and E sort of range. So, yeah, I don't think they're going to have too much of an impact. So let them come and fill out our form, essentially. But yeah, so I talk a lot about heat maps because we use them in statistics for a whole bunch of things. They don't necessarily mean we're looking at actual warmth in temperature. Sometimes it just means we're looking at color in temperature. Color being cool colors are at the, blue and green end. Warmer colors are at the red and orange end. So we did that when we were talking about, we did a heat map when we were talking about movement sensors, sensing movement between frames of video. We used a heat map for that as well. So heat maps are used for like a whole range of things. But because we started talking about it with relation to a CCTV camera, people automatically got the idea that when I was talking heat maps, it was to do with infrared heat, body heat, and stuff like that. So I just wanted to make that clear that heat maps are used for a whole range of things. But we're getting a visual cue here is there's a whole lot more heat on Bev than there is, favoritism for her. So see at the complaints level that Kev just posted a link for, I think you're right. But when it comes to state and federal levels, I think it does matter because, whether or not SCOTUS looks at a certiorari petition often does boil down to how the public is seeing it. Do they have to? Meh, the public's not up in arms enough yet. Meh, don't have to, push it aside. But when the public is up in arms and shit's going down, then they will look at it. But right now, that public attention is being drawn in another direction because you've got, nobody's into their current president, I guess, and that is overriding the public perception of this trial, and SCOTUS and state level courts are kind of overrun with that kind of public perception right now. That's drowning out our cries here, which is the whole point of making us louder with charts like this. So Commonwealth wants to prove they aren't a blue line mafia by getting Whitey Bulger's lawyer to clean up that image. The Commonwealth is always chopping its nose off to spite its face. If you wanted to prove you're not blue line mafia, why are you hiring a mafia lawyer? They're always doing stupid shit like that. So 2.3 Hazard in Hades. Right. With the feds it can, but it depends. Right, and it depends who's screaming the loudest right now. What issue is being the loudest right now? Right now the issue is everyone hates Trump, right? That's the loudest issue on the planet right now. It's even happening here in Australia. Our politicians are jumping up and down about Trump. So we've got parties here are actually supportive of Trump, and they're running in the current election, which I don't even know what date it is because I don't vote, but we do have a current election coming up. We have parties actually naming themselves after Trump. So, but then we have, a lot of people going F Trump. So it's even affecting our politics here in Australia. And that's the loudest politics going on right now. So don't mention that name. Only in context of what's screaming loudest right now is the only way I'm mentioning it. So it's drowning out, things that are actually meaningful to the public. So Chuck says Karen Read is a state Commonwealth trial, and the Commonwealth of Massachusetts was founded on nepotism and still operates on it. Here's the thing, Chucky. We are also a Commonwealth. We're also founded on the Commonwealth of, UK. Commonwealth nation of UK, Canada, exactly. Canada as well. New Zealand. Pretty much all the Five Eyes are part of the Commonwealth, right? So DOJ is a DOJ is a battleship, and it takes a while to turn around and level the guns. Well, that's very true. I want to have Kurt back on to talk about the DOJ, because when I talk about the DOJ, I'm talking in terms of simplicity, okay? Rhetoric for the sake of simplicity. So when I say DOJ is the oversight body, that's what we would call it here in Australia, and that's just simplifying it down to who's watching the watchers, right? What is your checks and balances? You're not a democracy if your checks and balances don't have oversight. So when I say, thank you, Kev, that's very true. If you're going to talk politics, you're out. If you're just going to agree with what I'm saying about that taking up all the attention right now, I'm good with it. We're not getting into politics here. I don't vote. I don't care what you think about Trump. I don't care what you think about Biden. I don't care what you think about our guys. I don't even like our guys. None of them. So I don't like your guys either. None of them. So no point in crying to me about it. But in relation to who's taking all the attention right now away from, the federal courts and stuff, it's definitely that. So our courts are shades of corruption, just like Massachusetts. So when you say ours, you're talking Canada, right? Yes, you are Canada, right? Canada let it go to them. Now we have Carney. They got rid of the lesser evil and replaced him with the max. Good grief. Right. So let's not get into politics now. We'll leave it go, because we weren't necessarily raising that topic because of politics. The DOJ is a federal government US-wide, not responsible for state. Each state has an attorney appointed by the DOJ called a US attorney. And this is true, Kevy, but you've just contradicted yourself in the same sentence. If the DOJ appoints the US attorney to the state, then who's the US attorney? They're responsible for the state. You will come up. All right, hang on. Let me bring Kevy up. Hang on. Well, let's go back. Explain yourself, Kevin.
Explain myself. Okay, the Department of Justice.
I got to put my headphones on. Wait a second, I can't hear you. Go.
Okay. The Department of Justice is nationwide.
No, I still can't hear you. Did I go to sleep? Hang on. I went to sleep. All right, now I can hear you.
Okay, the Department of Justice is United States wide. It's nationwide.
It's federal.
But the Department of Justice then appoints a U.S. attorney to sit in each state as their representative in the state. And it's their job to keep an eye to make sure that federal laws are upheld.
Correct.
It's not to oversee the state legal system, if you know what I mean.
Correct.
They'll only step in if federal law is broken.
Correct. That's the way people actually interpret me, using the rhetorical sense of oversight. So in the rhetorical sense, you are correct. I am wrong. Absolutely. And I think that's what Kurt was getting at yesterday.
That's exactly what he was getting at yesterday. I understand it from, I'm trying to think of the name of the program now. Is it Billions? It's explained very well in that the difference between the district attorney and the state's attorney. I don't know if you've ever watched that series.
Right. But what the DOJ is, and even what the USAO office is, it's an enforcement arm of federal law. So when they're breaking federal law, which they're doing as state actors, they're violating constitutional rights under color of law. That's USC. That's 18 USC section 242. If they're deliberately destroying evidence and doing all of the things that we're seeing them do, that is actually violating constitutional rights under color of law. That falls under USC section 18 USC section 242. So it's not just bad rulings, but it's willful misconduct. And that's the federal crime here. So they're not looking at how the state's applying its own law. They're looking at whether this is willful misconduct, willful public misconduct.
I can't
So
I
that's
can't
what
comment on what is and what isn't in relation to what Bev's doing. I would bow to Kurt or
Right.
to the likes of Andrea Burkhardt on that.
Correct. So that's why I say I would like to invite Kurt back up to talk about that, because this is my understanding. I do say it in a rhetorical sense that it's oversight, but if we want to get down to the nitty gritty, it's more about oversight on their corrupt or on their misconduct, and whether that.
Kurt last night did make the point
Sorry.
that the supervision of the courts in the state of Massachusetts is the responsibility of the state's Supreme Court. That's where the oversight of the courts lay. So all the misconduct that Bev is perceived to be committing would fall under their remit. It's for them or for the Judicial Commission to step in with complaints.
Only to the point that it's not breaking federal
correct,
law. Only
correct.
to that point.
But I think Kurt was making the point that that bar is a very high bar, and to his mind, she hasn't breached any of those laws yet, or broken any of those laws. Now he was making. He also said there may be reason, or there may be a point to refer her to the Judicial Commission for some of the things she's done.
Yeah.
But he was only trying to he was trying to clarify that difference to you last night.
Yeah, I did understand the difference. I absolutely did. And that's why I invited him back to talk on our channel about those differences, because there are clear delineations. But what we have here in this case is the DOJ has already stepped in. You know what I mean? They've already made that delineation. Something was going on that breaks federal law because the DOJ did step in, right?
Well, the investigations, I think, they can investigate anything. That's pretty much like the grand jury in a ham sandwich. So the feds can go in and investigate anything, really. But it's whether it rises to the level of bringing actual charges. And I'd say that's what happened. They came in and they investigated.
It's whether it raises to the level of breaking federal law. So now we're in a different territory, because the FBI is a sub-agency of the DOJ, right? The USAO office doesn't freelance investigations. They answer to Main Justice. So Main Justice obviously felt something was going on. We don't know what they thought was going on, but here's my guess as it relates to this case. If they have investigated and they see this murder was not committed by Karen, but all the evidence has been destroyed, they can't bring charges federally for murder like they've done in the Matthew Farwell case, right? They can't follow that through like they did with the Matthew Farwell case because all the evidence has been destroyed.
Yeah.
So what are they going to do? They're just going to go quiet again until they've got other evidence, not necessarily of the murder. It could be 18 USC 242, or it could be RICO. It could be that because they all colluded like they did, and DA Morrissey's orchestrating all this collusion, it could fall under RICO. I'm not saying it does, I'm not saying it is, and I'm not saying that's why they went quiet. I'm just saying it could be.
Well, the thing with the feds,
but that's a natural flow.
The thing with the feds is they operate in the dark a lot of the time. They could still be investigating. They could have just shelved the investigation for now, pending further investigation.
They could have just said, let's just go quiet and let them make up their own stories, and because it was just getting too public and they're not going to get their...
I'd say it's more... I'd say the initial suspicion of it being into the DA's office might be correct.
Right, I think so too. Just guessing, not saying any of this is true, just guessing.
But the other side...
But here's the thing about it... Here's the thing. If Bev has had extrajudicial communications with DA Morrissey, and that's found in his burner accounts, now all of a sudden she's under the spotlight by the DOJ. that drags her from SJC to absolutely under the spotlight of main justice, the federal
Right. That
right.
I would.
That's all we need is one message between her and Morrissey, and it's over.
You see, the way Kurt was explaining it last night, there's a great series of shows in what happened between you and Kurt last night that would explain a lot of the legalities to people, to the ordinary people like me. Kurt has a great insight of the separation between the state and the federal government, and the appellate
Correct.
issues and the criminality issues.
That's exactly why I wanted to talk with him, because I feel like he dismisses a lot of these things we're talking about right now as not real, that these are conspiratory theories that have been cooked up by people like Aidan Carney. I feel like that's where he comes from with that. But
No,
that's
I
not
think, to
how
be
it
fair
is.
to him, he did say he tries to leave emotion at the door when he's talking about this, and he deals completely with the law. And the problem with a lot of people in these chats, and me included, you get very passionate about it, and your emotion is driving your opinion.
Right, exactly. But see, I'm certainly not. I definitely get emotional and want to rage. I'm not going to deny that. But I am looking at the black and white, but I'm looking at it not from someone who studies the law like Kurt. I'm looking at it from somebody to whom the law affects. So that's a different perspective that may come across actually as emotional and in fact I am Aspie and there's very little emotion. It's pretty black and white. If that makes sense.
Yeah. It does really.
So there is the two different ways of looking at it, and I like to hear the black and white view of it, because black and white fits way better into my view of who to whom the law affects. Like we have in Australia, I don't know if you know this, but we have like this, our government has a measure of success of each government that comes into power through our votes. And that measurement is how many laws they made, common laws against us. How many common laws they brought in during their period of power. That's how they measure success by governments here. Like, that just tells you something about the two different aspects.
But that's basically the main job in most governments. Now, I know America is slightly different, but for European democracies and for the likes of Australia, politicians in all respects are legislators. Their ultimate job is to make laws. That's what their job is.
Right. So from someone who actually works in that government capacity to make the laws, then you're going, yay, we did good. But from someone who's at the other end, who the laws apply to, like myself, we're like, no, yay. That's not a yay at all. Do you get what I'm saying? But, so they're just two completely opposite ends of the spectrum.
Yeah. It's this is a rabbit hole we could go down and never come out of.
It's a big rabbit hole. But I can put it down to two completely different perspectives, and it doesn't mean that you can't listen to the other perspective. So when you're in a courtroom, Kurt's way of looking at it is what counts. Mine doesn't even hold up in a courtroom. I'm on the defense side sitting with the
point, and that's what Kurt was trying to put across last night, and he tries to put across in the show. Yes, he's a bit curt, pardon the pun, when he's doing it. He's a bit direct about it, and some people don't like it when he is blunt. But I do understand it. To me, Andrea is Kurt Light. She does the same thing. She was saying things there for the first couple of days of Jen's testimony, and chat was going bananas.
Stating the law.
Chat was going bananas with her. What are you talking about? He's killing it and blah blah blah. And she was saying, no, he's not, and he's making mistakes, and this is why he's making mistakes. And,
right. Well, people are getting very emotionally invested.
Oh, they are. 100%.
and I have to take some blame for that because, I heroized them by making songs out of their words. I turned them into heroes doing that. Not that was not my objective. My objective was more like, I loved their words, the way they said them and why they said them, and so I'm going to turn it into a song. But it did, in a way, invest people emotionally. That's my role in getting people emotionally invested. In
You
the
see,
case,
in the perfect world, the justice system would operate in a vacuum, free of interference, but it doesn't. In the real world, it's impacted by politics, it's local government, local personalities, and you've jurisdictional pissing competitions then going on between federal and state. Sometimes they have to work together, so they have to watch that relationship. So it's never cut and dry, and that's the point I think Kurt was making, that it has to be a serious breaches of these rules that lead.
And it does come down to interpretation of that law, because he might interpret it one way, and then Andrea, who understands it just as clearly as he does, might interpret it another way. So it does sometimes come down to interpretations. It's not really black and white either, is it?
No, it's never black and white, and that's the problem. The biggest.
One of the good things.
I asked, Carter turned off chat at this point from his own point of view last night, but I asked a couple of times his opinion about Bev's constant sighing and telegraphing to the jury whenever the defense were doing their cross-examinations. She wasn't doing that when Brennan was up. And that to me is a clear breach of the rules and an appellate issue. And I would have loved to hear his opinion on it, but I never got
it. Right. So what Kurt and I did end up agreeing on is it's a bad prosecution.
Oh, it's a bad prosecution. It never should have seen. It never should have seen the inside of a courtroom. If that was any other DA's office in the States, I don't think it ever would have seen a courtroom.
Well, we've even got a DA office out of Johnson County saying that. So, but yeah, the real legal question is, how did it survive this long? Because there had to be a whole bunch of willful misconduct going on in the background in order for it to have survived this long. You get what I'm saying? Yeah. We've got the evidence tampering, suppressing, retaliating. It's not just bad. It's like it is criminal behavior under 18 USC 242. It is criminal behavior because it's willful. So, again, willful misconduct under color of law. So when you start there and you go, it's a bad prosecution, you're actually agreeing that the DOJ should be involved. Do you get what I'm saying? Yeah. That it's willfully bad.
There's a big issue in the States, and this is somebody from Ireland that watches a lot of videos online and stuff and follows the true crime scene and looks at all the body cam videos, etc. There seems to be an ingrained thing in America where when you make a mistake, it's double down. It's never, well, hold your hands up and say, right, we got that wrong. Let's correct it and move on. There seems to be a huge fear of litigation and lawsuits. And they seem to think that the best way to do it is to double down, fight harder, and hopefully people will go away. And I think that extends into the judicial system as well, with district attorneys and that. Once they start the ball rolling, they're very, very, very reluctant to stop that once the wheels are in motion, even if they are in the wrong, and it's clear they're in the wrong.
That bureaucracy exists at any level of government, though. Like, even just for me trying to bloody argue about how I got, this was like 10 or 15 years ago, how I got my car registered, and then at the other end, at the rego department, they don't have my car registered. It's like, how the freaking hell did that happen? It's bureaucracy, right? Yeah. It's the same thing. It's like, if we just give you a hard time and pretend that didn't happen, you'll go away and you'll stop complaining about it.
Yeah, it's the same here in Ireland, and the UK is the same. I can't speak for the other European countries, but I imagine it's the same, especially with politicians, because politicians run basically on popularity.
Right. So we can talk about like how Morrissey potentially caught the attention of the DOJ under two different rules. The first one being, their original tension being caught by the Section 242, willful misconduct. Like, there's no doubt any of us don't believe there was willful misconduct to bring this to trial to begin with, right? Even Kurt agrees with that. There had to be willful planning behind bringing this to trial when everyone can see it's a shit case. So
yeah, the thing that still kills me to this day is why the Commonwealth totally ignored the FBI dump.
So if Morrissey knowingly, I say if, I'm not saying he did, just saying if, Morrissey knowingly allowed withholding of exculpatory evidence like the video footage or anything like that, we know that's actually true now, destruction or tampering of any evidence, whether it be digital or whatever, allowed the manipulation of any of the timestamps, like in the Waze, the health data, the Bluetooth logs, whatever. If he's allowed any of that, that falls clearly under Section 242. It starts, this is how 18 USC Section 242 starts.
Can you put that up on the screen? Because you're citing these laws and I don't know what they're referencing.
It's the same law that I've referenced the whole time, but let me get it up on the screen.
No, I know it's the judicial conduct, isn't it? The rules of...
No.
Okay.
No, this is the federal law. This is...
Apologies, I thought it was the one you used for the form.
Nope, that's SJC. Okay. This is federal law. Department of Justice. Here we go. Get this up on the screen. Share screen. Hang on. Go to the right screen. Share screen.
Good.
Hang on. Can I just press this tab? Hang on. This way. All right. So, Section 242, right? Whoever under colour of any law, any statute, any ordinance, any regulation, or any custom, that includes states, right? Willfully subjects any person in any state or territory, Commonwealth, possession or district to the deprivation of any rights, privilege, or immunities secured or protected by the Constitution or laws of the United States, the federal laws. Okay, that's who they have jurisdiction over.
Now I have context. All right.
So in that context, if Morrissey allowed any of those things to happen, withholding of exculpatory evidence, destruction or tampering of any evidence, manipulated any kind of evidence, whether it be timestamps or anything, phone data, whatever, he's not just being shady, he's denying Karen Read her 14th Amendment right to due process under colour of state law. And that's textbook Section 242, right?
Like everybody's talking about the huge lawsuit Karen's going to take when this is all over and she's found not guilty.
For sure.
Yeah, but is there grounds for that suit? That's the one. And who are the grounds for the suit against? You know.
Right, that's a completely other conversation. That's not federal, that's civil.
Well, it's coordinated. But anyway, yeah. But I have a feeling that could be what's driving the DA's decision not to drop this case. Because I remember hearing your man, the civil rights lawyer, I forget his name now, brilliant channel. He explained that in order to take a civil case against a state or a law enforcement agency, etc., the charges must first be dismissed. So they have to jump that hurdle first before they can consider doing filing a lawsuit.
Right, so civil's way down the track. Step 2 for Morrissey under Section 242 that we've got on the screen. Coordinated witness intimidation and retaliatory prosecutions. This is definitely a retaliatory prosecution, and we saw evidence of that in Jen McCabe's communications the other day. She testified that yes, they absolutely said if Karen Read doesn't plead out, this is going to be retaliatory. So if Morrissey targeted anyone else, though, like Aidan Carney, Juror A, or anything along those lines, through criminal process as a retaliation for lawful speech or protected court participation, then he would fall under this section 242, right? If he let police tamper with or manipulate the jury pool while standing back and like Pilates, for example, which he did do, right? That's First Amendment retaliation and in due process violation. And now you've got multiple civil rights deprivation wrapped up in prosecutorial discretion. A prosecutor's favorite shield, obviously, is their discretion. Being turned into a weapon. And again, that falls under section 242. Number 3, orchestrating removals of jurors based on vote leaning. So if he could see by reports coming back from the courtroom that juror A was appeared to be, smiling at certain points and frowning at other points that made her appear pro defense, and juror B was pro prosecution, and then they're removed not for misconduct but because one leaned not guilty and the other leaned guilty in just observing the jury. So if Morrissey's office played any part, any role in that whatsoever, then that puts him squarely under color of law, like weaponizing the court process to manufacture a conviction under color of law, right? So, and the kicker of that is actually the willfulness part, that he did it willfully. So under section 242 requires willfulness, that the state actor knew they were violating the Constitution. And oh boy, does Morrissey's office have a pattern of doing this and knowing it.
Yeah, 100%.
We got Michael Proctor's.
They're rotten. These prosecutors' offices are rotten to the core. A lot of them.
Right.
The amount of how would you say, wrongful prosecutions that they bring, and the amount of overcharging that's done is phenomenal in the States.
Right. And I think the biggest sign of that willful misconduct or willfully crossing those boundaries is definitely how his office is now defending Cannone at the SJC and habeas levels, although they backed off that at the SCOTUS level and put someone else in there. But that was actually a very loud sign for the DOJ or for the main justice to look more closely at him. Like the more he does, the more he's putting the spotlight on himself.
Yeah.
So that comes down to how the main justice is going to look at it, or DOJ, which is an arm of main justice. That's knowledge, deliberate choice, a track record. If the feds wanted to go there and ARCA's involvement says they've considered it, then Morrissey isn't safe under prosecutorial immunity if he's crossed into investigative manipulation or retaliatory conduct, or he's now representing the judge at the SJC level. He's crossing so many boundaries here.
Yeah, it's unreal. The fact the ARCA report was in that file from the feds, that was the single key piece of the entire report, to my mind, that the DA's office or the Commonwealth, Brennan or Lally, should have picked up the phone and rang ARCA and said, "Can you explain this to me, please?" Because it was the only independent testing, completely independent of the Commonwealth, completely independent of the defence.
No, but instead they turned Karen Read's murder trial into a political bloody battle by saying, "Oh, Rawlins is after me and blah, 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 and I'm not talking to the feds," and just turned it into a hot political mess. We should never be involved in a...
Yeah, but even for the perception of how would you say, to avoid any perception of misconduct, that and to show people on the surface at least that they're trying to search for the truth, you think they would have made that phone call. You can make the phone call, get the answer from them, and then discount them and just say you don't want to use them. But they never even picked up the phone.
No, they just went on the attack and turned it
Correct.
political.
And that to me speaks volumes about what's going on with the prosecution. And it's one of the big reasons I think that so many people find Karen innocent or believe in Karen's
Yeah,
innocence.
absolutely. So if we look at, we acknowledge this isn't just a bad prosecution. We're acknowledging now that there's actually a criminal enterprise where he's colluding with the police, he's colluding with the different departments, he's got his own investigative office doing things they shouldn't be doing. He may well be colluding with the judge. There may well be ex parte communications on his
I'm convinced
emails
there's
and
ex parte
phones.
communications going on. There's just too
Now
many
we're
strange
talking,
things happening.
Exactly. Now we've moved from plain and simple Section 242 into a criminal enterprise, because it's all hiding behind decorum in the court, but it's involving too many departments and too many different things that are supposed to be neutral, including the judge. So now it's moving into that criminal enterprise. We're talking RICO. DOJ's got jurisdiction over RICO. So now we go into the RICO stuff, which is, how does that fit into everything? You all can go and watch my video called The Reckoning, where in story format I kind of do explain to you in very much detail how and why it could be RICO at the federal level. So I won't do it here, but I did do a story format. So for those who want to actually understand how all of that criminal enterprising that Morrissey's doing could literally fall under RICO.
The problem with the feds, well, not the problem, it's in a way it's a good thing. They take their time. They will not move until they're ready to move, and they're convinced.
They have no choice. They have no choice because they destroyed all of the fucking evidence. They have no choice but to find another way in. Because the evidence, they've sold the house, they've got rid of the dog, they tore up the concrete.
If their investigation is DA Morrissey,
Even if it is DA Morrissey,
taking their time to build their case, and they won't move until.
Even if it is DA Morrissey who is hiding all of this information, that they tore up the concrete, that they destroyed the evidence, that he gave them the go-ahead to destroy their phones, even if it is DA Morrissey, and all of those people did that, and they still could have brought murder charges if they had that evidence, they're now stuck because they don't have that evidence to bring against Morrissey in this case. So now they've got to go about it a whole different way. It takes a lot longer to prove these other things.
The thing is, if they were already investigating DA Morrissey, it had a lot more to do with than the Karen Read case. And if there's evidence missing, etc., in the Karen Read case, it may not matter.
That's exactly why it's RICO. That's exactly why it falls under RICO, because it's 3 murders.
The point I'm trying to make is the feds could turn around and they could drop the hammer next week. They could turn around and it could be another 12 months before they drop the hammer. They will not move until they're ready and they're sure that they will get a conviction or they'll succeed. That's how the feds roll.
They're not going to do it on guesswork.
They're not going to do it on guesswork, and they're not going to jump in for the sake of expediency or to preserve Karen Read or to free Karen Read. They'll jump in for the sake of their case. That's how they're cold and clinical that way.
Yeah. So how it falls under RICO is you've got now 3 murders that DA Morrissey's covered up.
Well, basically. He's involved in that. His department is possibly involved in that. Yeah, and he's at the center of it, 100%.
He's at the center of all 3 of them. So when it comes to RICO, that's how it falls into RICO. When you've got, it only has to be, I think it's 2 or more. I can't remember if I said 1 or more, 2 or more, because it's been a while since I did that research. But I think it's 2 or more crimes.
I did it for the one down in, what do you call it, Fannie Willis's thing, Judge Gainesville.
The criminal enterprise has only got to be linked to 2 or 3 crimes, and that's RICO. Bam, they're off on RICO, on that federal jurisdiction. So that's why I think it's going to take a lot longer, because they don't have, like in Matthew Farwell's case, for example, they moved on him right away. As soon as Karen's court case finished, bam, they were on his ass. Like, what was it, 2 weeks later? A week later, they already arrested him. It's because they had the evidence. The evidence wasn't destroyed in his case. They had the evidence. They could move on it straight away because they had the evidence. So that's an example of how and why they would move a lot quicker when they actually do have the evidence. But right now, because all the evidence been destroyed in Karen Read's case, they're going to move about this a different way, and it takes a whole lot longer to prove a RICO case.
But
now that you've got the elements,
has all the evidence been destroyed, or was it destroyed before the feds managed to get their hands on it? You'll never know until it sees the light of day.
Right? Did they investigate Brian Albert's basement before anyone else knew of it and were looking at these things? We don't know. We don't know what evidence they've got. I feel like if they did have the evidence, they'd arrested everybody by now and put Karen's case to rest.
I have a few suspicions based on the way that the defense has totally changed their strategy. I think there might be one or two surprises they have up their sleeve coming yet.
Oh yeah, AJ already hinted at them in his opening statements.
And some of the motions that were made, the pre-trial motions too, there was hints there as well. And
and then Brennan panicking, the arc is still in. That's definitely a hint that they're still afraid of the feds.
Well, they're still afraid of the feds, but I have a funny feeling Brennan was boxing clever. I remember hearing one of the lawyers explaining why Brennan was taking the tactics that he was taking, and it wasn't so much to exclude Arca because that was never going to happen. It was to pin them to the testimony that they've already given, not allowing them to do extra testing, etc., which is something that he argued in the week before.
I look less into his. I look far less into his strategy than I do into the defense's strategy.
Yeah. And the other thing is, too,
so you could be right.
A few lawyers have made this point. Brennan's not the cook and the bad lawyer that everybody makes him out to be. He's a smart cookie, and he's a devious little cookie. And you underestimate him at your peril.
You only have to look at the mobster trial that he was involved with to see the way that he operates, that in all its devious, undertakings and how he put those things across. So
he's been tasked with a job. D.A. Morrissey didn't go out of his way to get this fella for nothing. He's got a building full of attorneys. He's attorneys falling out the windows and the DA's office. But he went out of the office to go and get this guy to fight this case, this high-profile public case. There was a reason behind that, and it's not just that he's dirty or whatever. I would still sit on the fence with whether he's dirty as in bends the law, breaks the law. But he certainly fights dirty. He's not afraid to fight dirty, but within the bounds of the law. Okay.
So I just want to look into whether or not Higgins is considered a Fed under federal law. I mean, we all have our own ways of interpreting what we think.
He's ATF, isn't he?
He's ATF,
they're
correct.
They're federal agents. The ATF is a federal agency.
I think they actually are feds.
Alcohol, tobacco, and firearms.
Right. ATF, Bureau of Alcohol, Tobacco, Firearms and Explosives, is part of the U.S. Department of Justice. It used to be under the Treasury Department, but after 9/11, it was shifted to the DOJ. So in 2003, that happened as part of the Homeland Security reshuffling. So yes, it's officially a DOJ agency. Officially, he is a Fed. But whether you want to literally give him that title or not, I guess
he is a Fed. But from what I believe, it's common practice for some of these agencies, three-letter agencies, to place agents within police departments or within district attorneys' offices for expedience. So they're on their boots on the ground in a local area. Sometimes they'll have their own office, so the ATF will have their own office. But if it's a smaller
but they answer to the DOJ, and the DOJ answers to Main Justice. So technically, he is a Fed. F-bomb. They did that in trial 1.0. They pretty much asked every single witness, not civilian witness, all the cops about proper investigation procedures. They did ask them, but they denied it. Some of them were like, no, that's not how we do it in the snow, or we were never trained in the snow, or
Oh, you
it
can
was
rest
stupid
assured
shit.
when the police come up now, Alan Jackson or whoever's doing the question or the cross-examination, he'll go through the manual.
Right, it was Whitey Bulger. Thank you, Chuck. I don't know why these names fall out of my head. It happens with names of places and names of people, just nouns in general. If it's a noun, I'm going to forget it when I'm actually talking about it. So I apologize for that. But yes, Whitey Bulger is who I was referring to. So yeah, interesting all round, right? So have we covered all the topics? Let me just check my list here of all the topics. Since we've got a few on the stream still, rather than just ending the stream, shall we break down my storytelling on the Rico? Shall we do that?
Yeah, go ahead for it. Go for it.
Let me find the video first. Generally, I would send.
We should post up a link there to your survey or to your questionnaire.
Come on, YouTube. What are you doing? Reckoning is what I called it. No, sorry, to the reckoning is what I meant. I'm sorry. I wasn't listening to you properly. I apologize. Because I was looking for this. Let's get past the ads so we don't have to do that. Oh, more ads. Nope, not more ads. All right, story time, boys and girls. So what we will do is we'll stop it occasionally for interjections. Stop it occasionally for commentary and interjections. How's that? Right, back off with the ads. Here we go, boys and girls. We'll get past the intro so you don't have to listen to that.
Right, that link's in chat there now.
Yep, thank you. Turn up the volume. Here we go.
People do.
This was never supposed to see the light of day. Not the footage, not the files, not the truth. A police officer is dead. A woman is charged. But behind the headlines lies something far more dangerous than a single crime. An entire ecosystem built to conceal its own corruption. They destroyed phones, erased footage, gagged the defense, threatened journalists, silenced jurors, all to protect the few and damn the one woman who refused to back down. This isn't about an accident. This isn't about a bad prosecution. This is about the quiet machinery of power cranking away in the background, hidden beneath the surface. A network of prosecutors, police, judges, and enablers who don't need to conspire aloud because they already know the script. So the judges that we do know are involved were mentioned in Morrissey's emails, right? Morrissey sent a message to, I can't remember which judge it was exactly, and told him to change his, he'd already ruled on Aidan Carney's hearing that day, ruled on it. Then Morrissey contacted him and said, no, change that ruling because XYZ, and like that's ex parte communications with the judge. And then the judge changed the ruling. So I can't think of his name, but to assume that Judge Bev's not in on that whole thing.
Absolutely. There's a lot of shady shit going on in this whole Aidan Karen Read thing. And it's finding the evidence that allows somebody to take action. And that's the problem. As Kurt said, was it what was that called? Habeas appeal?
Yeah.
He called it from day one. He said there was nothing there to that appeal. He knew it was going to be denied. Everybody else was hoping it would succeed, but that was emotion driving them, whereas he was looking at it on its
right. And even my assumptions were not emotion based. Mine were just based strictly on numbers. Which ones by numbers have the best chance of getting through? That mine wasn't even emotion based.
Yeah, it's.
But yeah, that I just wanted to point that out that there are judges in Norfolk County who are all involved in this. So just to add to the story that I was telling.
Like we all see stuff that's happening, and bizarre coincidences that are happening. They're all point to collusion and to ex-party meetings, but it's proven it.
Mm-hmm.
It's like Judge Glanville having to recuse him, eventually being forced to recuse in that young thug case.
Yeah. Well, the proving it
had,
in Aiden's specific case, the proving it was in that email that Bedro got his hands on. That one's proven. But with Judge Bev, you're right, it's not proven.
Yeah.
That's exactly why she said, "Oh, Brennan, you can be the tank team." So
yeah, but like why I don't know what grounds there are to force like the whole DA Morrissey with his auto delete. I don't know how he's allowed to do that.
Especially after she's just reprimanded the defense about it.
Yeah, but with him, given the position that he's in, he shouldn't be allowed to do that. Fine if it's his own personal phone, but if he's using that for work, he shouldn't be allowed to use that auto delete feature.
Yeah.
And it should always work against him in any case where it comes up. It should always work in favor of the other party. I think that would fall under spoliation, I think, or the principles of spoliation.
Right. All right. So we'll move on to the next little bit. It hums in courtroom chambers. It whispers through sealed affidavits. It clicks into place every time a judge denies a motion, every time a witness forgets, every time a hard drive goes missing. Once the lies are stacked too high and the evidence piled too deep, this story doesn't stay buried. And the more they try to rebury it, the more they're bringing attention to it. You can hear the low... So I would just answer your question. Take this back 1 second. I'll just answer your question, Dandelion. That's what we're playing now. We're playing whether or not I think the feds are done. All right? It's not been confirmed or denied. So we just got people saying it on the stand now. But let's finish this video because this is where I am discussing whether or not I think the feds are done. So I'm doing it in story format, and I will pause occasionally to talk in real terms rather than just story format. You can hear the low grind of favours owed, the rustle of secrets being papered over, the soft shuffle of courtroom chairs being filled with the wrong people, and the loud, deliberate silence when it's time to speak the truth. That's the sound of power preserving itself. The federal government has seen all the messages, heard all the whispers, read all the names, and now they watch. In silence, true, but for what reason? This is more than a case. It's a reckoning, and reckoning always comes. The Department of Justice spent just over $500,000 on only the ARCA experts alone. David Yannetti told us, for the first time, that DOJ subpoenaed their files. This tells us they were investigating something else when they tripped over Officer John O'Keefe's death. So what were they investigating? We know when it comes to these types of investigations, the DOJ works very slowly. Yet, within days of Karen Read's trial ending in a mistrial, the DOJ swept in and arrested Matthew Farwell. How did Matthew Farwell come to their attention? As far as we know, Sandra Birchmore's family has been lobbying the federal government for quite some time about her death. About a year before that, the family of Justin Root started lobbying the federal government about his death. Both families are crying foul, and with good reason, it turns out. We know that Sandra Birchmore and Justin Root are linked to agencies or individuals within the same law enforcement and the same DA's office. Matthew Farwell's arrest is confirmation that the DOJ is onto something much bigger. They can't just interfere with state murder charges. They're confined to a specific set of circumstances that would constitute breaking federal law. So I think I was pretty clear about the delineation there, what their jurisdiction is. The feds can actually investigate murder. They indeed investigated murder in Farwell's case. He is indeed charged with murder at the federal level. He's actually charged with, I do go into what the charges are in his case in this next section. So if you hang in there, I will go into that in more detail. So everyone knows that the feds are watching, don't they, Dandy? And, you know, we heard Wolf say it on the stand and during voir dire. The feds were watching and they still are watching. So, Kevy, can you mute when you're not talking so we can't hear all the background noise?
Oh, sorry.
That's all right. But yeah, only when you're not talking. I'm happy for you to unmute and talk, of course, obviously. But I'm trying to do the same so you don't hear all my background noise too. So yeah, I just stopped to go through the questions and comments. Kevin, good to see you. All right. You're going nuts, Compo. You're nuts. Like the rest of us. We're all nuts. All right. So I'm going to go into the actual charges at the federal level. Murder itself could be charged by the state. However, that is not what he's charged with. He's in fact charged with killing of a witness or victim with the intent to prevent their communication about the commission or possible commission of a federal offence. The indictment alleges that Farwell killed Sandra Birchmore to prevent her from disclosing information related to his involvement in several federal crimes. One of them involves coercion and enticement. This charge pertains to using a facility or means of interstate commerce to knowingly persuade, induce, entice, or coerce an individual under the age of 18 to engage in unlawful sexual activity. So that's a USC statute, just like the 242 that I was just showing you. He's also charged with wire fraud. This charge pertains to his alleged scheme to defraud the Stoughton Police Department and the town of Stoughton by falsely representing his work hours to receive compensation for official time during which he was actually engaged in personal activities, specifically with Sandra Birchmore. And thirdly, deprivation of rights under colour of law, alleging that Farwell, while acting as a police officer, violated Birchmore's constitutional rights. So the fact that Farwell was able to be contained into specific federal legislation without tipping any hands as to the broader investigation going on is why he was nabbed shortly after Karen Read's trial. But the fact that they waited for Karen Read's trial to end first says a lot. Justin Root's family, well, one of the biggest things that it says is they had evidence of that crime. They had all his texts and private communications. So they literally did have evidence of what he had done. That's why they were able to jump on this very, very quickly in Farwell's case. Went about things a different way. They went through a civil procedure. In the wrongful death lawsuit filed by Justin Root's family, the court granted summary judgment in favour of the officers, citing that their actions were reasonable under the circumstances and that they were entitled to qualified immunity. Why? because DA Michael Morrissey protected them. He found no wrongdoing on their part. Interestingly, DA Morrissey also found no wrongdoing on Matthew Farwell's part. And now you have a very interesting connection between the two cases. What does Karen Read have in common with them? The same connection, DA Morrissey. And not just DA Morrissey on his own. Each of these deaths is linked to agencies or individuals within the same law enforcement, prosecutorial or judicial network tied to the Read case. The frequency, proximity, and uniform strategy of suppressing scrutiny and evidence, etc., suggests coordination consistent with racketeering behaviour, or RICO. So what's RICO, and why would the feds get involved? RICO is a federal law designed to combat organised crime and corrupt enterprise behaviour. While originally used against the mafia, it has since been applied to public corruption cases involving patterns of coordinated criminal activity. A successful RICO prosecution requires showing an enterprise existed, either formal or informal group functioning as a unit, the enterprise engaged in a pattern of racketeering activity, which is typically 2 or more predicate crimes within 10 years.
Introducing our cutting-edge Smart Zoom reading glasses, co-developed by NASA engineers.
Sorry about that. Ads got me. Let's take it back a bit. So, do you see how the feds categorize RICO now? If you've got a bunch of people doing a bunch of shit that's breaking any federal law, like 242, and they're all doing it in collusion with each other over multiple crimes, now you've got RICO. It's not necessarily restricted to gang members and mafia. It covers public corruption as well. So it's very interesting. What did you want to say, Kev?
No, I was just going to say that I think the feds have had their eye on the whole Massachusetts and Norfolk situation for a long time before that too, because there was a few high-profile corruption cases, especially in the Massachusetts State Police, I believe, or was it the Boston Police over overtime?
Yeah.
I forget now, but there was a massive amount of arrests and prosecutions over that.
So you're talking, I think, about the two things that Aidan uncovered. The one was the drug scandal, the drug lab scandal, and the other one was
that was one of them, yeah.
The licensing scandal, where they were getting kickbacks.
That was another one, yeah. They're all running their own little side schemes, it seems.
Yeah. 50 MSPs were arrested in the licensing scandal. I think it was around 50. And then I forget what happened. I think it was thousands of cases got a new trial because of the drug lab scandal. So that's been going on there for a long time, and Aidan's been covering that for a long time. Like, this isn't his first rodeo as far as exposing DA Morrissey's office. Let's just say
no,
that.
and it totally explains why they're going after him with everything that they've got.
Right, it's not just Karen Read's trial. It's
all
of the shit that's going on. He's been the one to shed the light on it because the mainstream media won't.
Yeah, 100%. The mainstream media is dead and buried at this stage, in my opinion.
Yeah,
I think it's just a bunch of grannies and granddads that are sitting down in front of the television with nothing left to do but watch it.
Right, exactly. Exactly.
Um,
All right, we'll go on with the next section. Is one of those crimes. Whether Justin Root or John O'Keefe is the other, or both, we're yet to find out. The other things that they need to look at is also that those acts were committed in furtherance of the enterprise's interests, i.e. protecting each other and the DA's office, and that the acts impacted interstate commerce, hence the wire fraud charge against Farwell. They already had enough to indict him on the other two charges, So throwing the wire fraud charge in there may seem a little left of centre unless you understand it in the context of RICO. So how does Officer John O'Keefe's case affect the Interstate Commerce Clause? Courts generally interpret interstate commerce broadly. In the context of this case, federal equipment misuse by ATF agent Bryant Higgins, digital evidence and cloud services, i.e. ring camera data, iCloud messages and GPS data, they all rely on interstate networks, so any tampering, withholding or falsifying of digital data affects services that cross state lines. So do you understand how these international services like Ring and all of these things, even just across America, brings the federal sort of angle in, because they're using all of these different services to get the data into this court case, and then they're fiddling with that data. So that's how it becomes a federal crime, because they're not local services. Any false statements, filings, or tampered digital media transmitted by email, post, or digital platforms constitutes wire or mail fraud. They are both RICO predicates. Oh, and guess who's been transferring emails and statements and lies and shit using these forms and profiting off it? Guess who's been doing all of that? Kate Peters. She's been doing that. So, and also Lindsay Gattani. She's also been doing that. Everyone who's trying to get Aiden thrown in jail, they're all got their own little forums and using, national platforms for revenue generation. They're all been involved in it. You could even stretch it out a little bit and include media targeting via national platforms, like, for example, Kate Peter, Lindsay Gattani, and Natalie Wawicki, if they used Patreon, YouTube, and social media to retaliate against defense supporters. These are revenue-generating interstate platforms. On that note, you could also include Trooper Tully crossing state lines to secure the cooperation of Natalie Wawicki, an individual now acting on behalf of the Commonwealth. Her involvement under an undisclosed immunity deal further supports the federal commerce impact. And finally, DOJ involvement and grant funding. The DOJ's TUI disclosures, the ARCA report, and possible misuse of federal grant funds by local police departments all represent tangible effects on federal commerce channels. Thus, under RICO, the threshold for federal jurisdiction is far more than met. The predicate crimes potentially supporting a RICO charge include federal authorities examining a potential RICO case would consider the following major incidents as part of a pattern: the death of Sandra Birchmore in 2021, the death of John O'Keefe in 2022, and possibly the killing of Justin Root in 2020. We can also throw the death of Trooper Enrique Delgado Garcia in there in 2024, whose death was swiftly ruled non-suspicious, echoing patterns seen in other covered-up cases in the region. The big question is, why is Cannone throwing herself in the middle of all of this? She presides over a case where she has personal ties to the Alberts. Remember, Chris Albert was represented by her brother in a hit-and-run murder case, which he somehow escaped the charges for. And we're pretty sure she's blown her own judicial immunity by appointing an SPDU officer, Trooper Fanning, as courthouse security, even though Fanning doesn't work in that capacity for SPDU or for Massachusetts State Police. He's then later tied to the... Oops, I was muted. Just before we go on, there's something else we found out about Fanning in Walsh's case, is that he's actually in charge of the sexual crimes unit. Like, holy crapola. I think it was a sexual crimes unit in DA Morrissey's office. So But yeah, that's something we found out when he was testifying in the Walsh case. So, gotcha, Kevy, you're back. I didn't mute you, by the way. Dismissal of Juror A. And we know this is an issue because Judge Cannone made such a big freaking deal out of it. She knows it cancels her judicial immunity. So why she's throwing herself into the middle of the tightening RICO web, Lord only knows. From embedded SPDU officers acting as prosecutorial agents, to suppression of critical video, to witness intimidation using civilian proxies, to collusion between prosecutors and judges, this case isn't just mishandled, it's coordinated. If, big if, but if the federal government is pursuing a RICO investigation, the following patterns would be central.
Overcharged overseas? Make it the last time. Avoid exchange rate markups and high transaction fees when you spend.
Sorry, guys. Gotta do it. I gotta watch my own ads so I can make some money out of it. Oh, these are not 5-second ads that we can skip either. Let me put the link to the scorecard into chat and pin that so you all can go replace the pin message now. So you all can go and fill out that card when this is done. Grifter. I am a grifter. Are we on bloody skip yet? Yes, we are. All right. Let's just take it back a second or two so that you can hear where I was going with the comment. But if the federal government is pursuing a RICO investigation, the following patterns would be central. Obstruction of justice, retaliation against journalists and whistleblowers, use of public office to cover up a crime, witness tampering and coordinated testimony, judicial bias shielding conspirators from exposure. The DOJ's TUI disclosures alone provide strong indication that the federal authorities already know everything. The communications, the group texts, surveillance irregularities, and suppression tactics from a textbook example of racketeering behaviour by a state-sanctioned enterprise. This is far from a local corruption scandal. It's a systemic pattern of racketeering involving police, prosecutors, civilian actors, and possibly even judges. And when you include the cases that Kevin just raised, the overtime scandal and the drug lab scandal, it goes on, right? It keeps going on. I didn't even include those in this particular tying it to Karen Read's case. It might not be tied to Karen. There might be other things, other patterns that the DOJ's noticed that's causing him to look into this one or this set of cases. So the Karen Read case is not only a legal battle, it may well be a case study in modern RICO prosecution. It's no longer about what they covered up, it's about how far they're willing to go to keep it covered. In this case alone, we're looking at a massive tangle of digital, legal, and governmental actions that stretch across agencies, infrastructure, and state lines. That's why the feds are watching. This case has never been about one person, one single mistake, or one tragic night. It's about how the system's designed to ensure justice will weaponized to prevent it. When state actors, law enforcement, prosecutors, judges form an enterprise that silences dissent, destroys evidence, and manipulates public perception, the local system can no longer be trusted to self-correct. That's why federal jurisdiction matters. The federal government has the tools, independence, and jurisdictional reach to investigate multi-agency misconduct, subpoena across state lines, charge conspirators regardless of badge or bench, and protect witnesses, whistleblowers, and journalists from retaliation. With the DOJ's TUI disclosures, the ARCA expert analysis, and whistleblower testimony now in federal hands, The web of cover-ups, collusion and misconduct can no longer be ignored. I don't think this case is any longer about whether the feds will act. I think it's more about when. And when they do, the Karen Read case will not just be a case about one woman's fight for justice. It will be the reckoning that finally holds the corrupt structure around her accountable. This is the moment federal jurisdiction was made for. When the reckoning comes, whether by appeal, habeas, or the federal government stepping in, it won't be because the defence shouted the loudest. It will be because they never stopped telling the truth. So for those who are worried about the appeals, they haven't appealed for every issue yet, not now, not yet. Because sometimes the best way to prove the system is broken is to let it break itself. This is what the DOJ is made for. And here's a little tip. If they're building a RICO case, Higgins isn't just a witness or suspect. He's the breach point between a state-level cover-up and federal accountability mechanism. He's the guy who crossed jurisdictional lines, literally and legally. He was the first one to crack and say that he saw a tall, dark-haired man enter the house. That's not flipping. That's protecting himself. But the proffer he made in court doesn't protect him from RICO. If he wasn't the primary perpetrator or aggressor, it'd be risky to admit John was inside. That admission establishes opportunity, places John in proximity to him, and implies Higgins knows more than he's saying. So why say it? Because it likely wasn't Higgins who struck the fatal blow, and he knows it. Everyone who is called to testify at the federal grand jury, they all know it's coming. The DOJ does not rush. It creeps on quiet shoes through sealed courtrooms and buried files. The DOJ does not shout, it listens, logs and builds, brick by brick, lie by lie. RICO is not fast, it's deliberate, and when it moves, it does so with the full gravity of the law. Those who thought their badges, benches and silence would shield them will come to learn justice delayed is not justice denied. Because when the reckoning arrives, it doesn't knock, it kicks in the door. There you go. So that's what I think the feds are doing, in a nutshell. Why I think they're doing it, what laws I think they are pursuing federally, what their jurisdiction is, what I think the players are doing to put themselves into those little brackets of scrutiny. So, yeah, if you want to watch it without me interrupting it and saying more stuff on top of it, please check it out. Oh shit, I just closed it without posting the link for you. Oh, hang on, let me just do that again. Should be in my history list.
I'll post it for you, don't worry.
You did, thank you. On top of it, Kevy. So I did pin the link to the form for those who haven't filled out the form. Please go do it after the show so that you can be included. Get your voice out there. So the main thing I guess we're looking for is letting, the authorities in America know that we're not just going to sit back and be quiet. There might be other things taking their attention right now. So we need to make noise. And this is how we're going to make the noise. We're going to tell them we're watching. So the other day during, whose testimony was it? Before Jen's testimony. Who was the one before Jen? Kevy, can you remember? I've already blended my days together. I can't remember who's
Whiffen
who.
was before Jen, I think, wasn't it?
Whiffen, exactly.
Whiffen.
So during Waffle and Whiffen, during his testimony, they were doing polls on all the different channels. So I think it was Melanie Little, Andrea Burkhart, Court TV, Law and Crime, and who was the other one? Emily D. Baker, I think, were the 5 that actually did do polls, and the polls were still up around 90%, no matter what question was asked. Whether you think Karen Read was innocent or whether you think she was going to get convicted, those were very, very low scores. Innocent, all up around the 90%. And from those polls, we got, from 5 polls, 5 channels, we got around 1.3, it was 1.289 or something, 1.3 million people tuned in just that day that Whiffen was testifying. So,
Remarkable figures.
So yeah, these are big figures.
Yeah.
They're not just small figures. So to compare that with the Johnny Depp trial, I think we had, if I remember the stats, early in the trial, we were up at by about witness number 2 or 3. That was a civil trial, obviously, but we were in and Johnny Depp's a pretty big name actor, right? So the figures were around the 1.3 to 1.5 million within the first couple of testimonies. So we're kind of running along the same stats as the Johnny Depp trial as far as people actually watching it. So I think we can make a loud splash. I don't know how we get this information to anyone in authority that's going to go, wow, there's a lot of people watching. However we do it, let's get the numbers up. Let's get that 1.3 million listed here on the form. And for those who are local in the Massachusetts area, or those who are local to at least one of the US states, it's important for you to make your complaints known and send them the link to this. So the link I've got pinned is to fill the form out. When you're done filling out the form, you'll get the link to this. That's the link. This results page is the link that you want to forward to your local representatives or whoever you're complaining to. So I'm not sure if you noticed, but the First Amendment YouTube community is starting to pay attention because of Bow. There you go. I didn't know that. I knew that they were paying. This is one of the things that I liked about meeting the community out there, especially the boots on the ground that are protesting and stuff, is I very quickly learned that there is no political divide anymore. This is one thing where everybody agrees on everything. You got lefties, you got righties, you got First Amendment auditors, you got everyone all in the same boat going, this is BS.
Yeah, and it all comes back to local politics. All politics is local. And I think the pressure's starting to show because your man Connolly voted out of the Canton Select Board. Rafferty's after jumping ship. The change is happening. And it's whether that pressure reaches up to the Morrissey's level. I'd say Morrissey's sweating because there's a woman running against him, I think, in the next election next year. He's run opposed the last 1 or 2 times, I think. Maybe somebody in chat could be more clear on that.
Rafferty definitely bailed ship at the right time.
She did,
didn't she?
100%. And she could see it coming. There's trouble coming.
Hey Tony, thanks for joining us. I love you guys too. All right, so this story here is pretty important. This is pertinent to what's going on because we just talked about the drug lab scandal, the overtime scandal. We talked about the Karen Read case, the Justin Root case, Sandra Birchmore, Trooper Enrique Delgado Garcia. All of this is included, and we have another story just to add to the entire mix. So this guy is a lawyer, Michael Welchlaw. This case has caught his attention because he spent 60 days in Norfolk County Correction Centre, and it was because of DA Morrissey. So surprise, surprise. Know who else got framed by Morrissey? And his Leo pal who's now a judge? Me. 60 days in Norfolk County Correctional Center. Guess how it happened? I asked for a divorce. How the hell do you end up in freaking jail for asking for a divorce? My ex was buds with the Norfolk sheriff, and her sister was chief of staff. The NCSO, general counsel, represented her to get a 209A against me. What's a 209A? Anyone in the chat? Let me look it up. What's a 209A? Let's see what it tells me about a 209A. I'll continue reading before I tell you what a 209A is. And they immediately filed false police reports until my bail got revoked 3 days later. Sound familiar, anybody? The general counsel is a judge now and close friends with Morrissey. The sheriff was Jerry McDermott. He does say that it's not Jimmy McDermott's relation. The general counsel was Robert Harnias. Robert Harnias is now a judge. Wait until you hear the rest. Oh, and I won 8 cases in a row, including a trial that I testified at and was acquitted within 50 minutes. Even charged me with witness intimidation for posting on Facebook about how corrupt they were acting. What? Wow, it's a playbook, right? Like, it's a regular playbook for sure. Kevy, the Superman, the Supermod. Let me share this tab. A 209A is abuse, the occurrence of any of the following acts within the family or household members: attempting to or causing physical harm by asking for a divorce, placing another in fear of imminent serious physical harm, causing another to engage involuntarily in, force or threat or duress and coercive control. Wow. There you go. That's what a 209A is. Interesting. So I wanted to show you the video. I know there is a video here when I see it, of one of DA Morrissey's goons, namely, at the time, Brian Albert, coming into this guy's home over his divorce. I know it's here. I'm getting a lot of ads. I'm not seeing it. It must have been in a comment under. It must have been under a sub-comment. All right. Quick way to find it is go here, because I know I posted it. About the goons, the goon squad. Here we are. So this is Brian Albert make an entry into this guy's house over a goddamn divorce, for Pete's sake. It's a protective or restraining order for DV. That's a 209A. Thank you, Kevin. Feel free to say these things aloud. You are on microphone. The DOJ literally has a pattern and practices interstate. Sadly, it was put on near complete hold. So don't hold your breath. Yeah, well, I try to have hope that, our systems do eventually fix themselves up, even after hiccups. So.
Okay, this right here is a search warrant for the house, which is allowing us to come in now to check and make sure he's no gift. Okay.
Can you take off?
We're not going to be able to take off our shoes. That's not safe for us to bend down and take our shoes off. We'll wipe our feet, but we can't take our shoes off.
I mean, like jerk off.
So is there anybody here besides you?
No, it's just myself.
You're the only one home? Okay. All right, why don't you slide into the beginning room? And then, no, just come in here. Come in here. Don't worry. No, I know, because you can't move around, so we're kind of doing what we're doing. No, I didn't say that.
There you go. And in case you missed it, that female cop that came in was in fact drawing her weapon. Crazy town over divorce. So yep, that's pretty much how it all goes. You don't have to have any proof, you just got to claim it. And next minute you got the police in your house drawing their weapons on you. So in a sense, it's kind of a it's the same thing as swatting, right? Doesn't matter sort of what you're claiming to get the cops to go there with their weapons and potentially hurt somebody. It's still swatting, right?
Yeah, it's basically the same thing.
It's not. So for those who don't live in gamers world, swatting's been around for a long time, but a lot of the states brought in new laws against swatting. So you can't just ring the cops and make a false allegation that so-and-so's in his closet because he's threatening self-harm, and then all of a sudden the entire SWAT team turns up because someone got killed. 2 people, actually. 2 gamers were killed from swatting. So then trying to get all of the states to make laws against swatting. But this kind of thing that we're looking at here, this is a domestic form of the same thing. Basically, you claim abuse, so the cops turn up with their guns drawn. It's the same thing, essentially. So it's disgusting. It's awful. If you want to follow Michael Welsh, just look up his name, Michael Welsh. His handle is at Michael Welsh Law. And he posts some very interesting things about his case. He's telling you about a lot of stuff, like because he knows people are going to come out and try and diss him because he's speaking out. He knows all this stuff's going ahead, so he's going to be talking about, what cases he actually is involved with, so that the rumors don't get. He's getting ahead of the rumors, basically.
Yeah, Michael's been very critical and very supportive. He's been very critical of the DA's office in Norfolk, but I think the wider Massachusetts legal system. And he's also got his own story to tell. So I'll post a link to Michael's page in X there if anybody wants to check him out.
If it makes you feel any better lurking, these are very, very common systems that happen here in Australia as well. I know countless dudes that have gone through it as well. They've had their children taken away from them. They can't visit their children. They've got no access because of false claims. So I don't think this is strictly a US problem. This is a Western civilization problem. So, and then they force you to make excessive child support payments. Exactly. So, you're talking about Welsh. Did Welsh say this? I'm obviously not following. Overkill, Carol says. May not be the correct term, but obviously the donut shop didn't have any meals of food ready for these cops. Right? So there you go. Thought that was just a very interesting case. Oh, you are talking about Welsh. Okay. If you don't want me to say your name, turn in your badge. Right. Because you're a public official. At the point that you're a cop, you're a public official. This is what annoyed me about Turtle Boy's court hearing, was that is that public now? Do you know, Kev? Because I know they didn't stream it, but I think it is public now.
Which is that? Sorry.
Turtle Boy's court hearing. The other day they tried to revoke.
It's on Turtle Boy's channel. I can post the link if you want.
Yeah, please do, and we'll have a look at that just to close out with. Like, so one of the things that they said in that was that, Turtle Boy was harassing Tully. He's the freaking cops. He's a public figure. He's got a gun and a state behind him. How is Turtle Boy threatening him by saying shit on a YouTube channel? Oh no, I triggered Siri again. Here's the funny thing, Prince, is Siri supposed to only be triggered by the accent. Not, I don't have an American accent, right? So this is an hour-long court case. Do we want to sit through the whole hour? We might as well. I don't have to go anywhere. Do you? We'll stop it and do some feedback because some of it really pissed me off. So we may end this as a rage stream. Some of the shit that this guy said really pissed me off. And for the reasons that Bradel pointed out too. So we will watch the rest of this for those who are still with us and wanting to see it. So what did Siri do, Prince Lover? What did Siri do? What did I tell Siri to do? Hopefully not swat your house or anything. Tell you may find out. Right. All right, let's hit the play button. You're finished yapping over there? Good. Let's move on. Let's get...
Special Assistant District Attorney Robert.
And there's another attorney on the call. Good afternoon.
Wow, shocking sound.
So there are a couple of motions that have been filed and other matters. Before we get into those, can I see counsel at sidebar?
Oh, great. We start with a sidebar. Surprise, surprise, everybody. Sorry, coffee drink. Let's get past the sidebar.
Your Honor, I think the first order of business, I would at least like to take up the issue that has been hanging for quite a while regarding the search of the seized devices and the memorandum that I filed in response to your Honor's order last time in opposition to what I understand to be the defendant's motion to screen other things besides attorney-client privilege, specifically reporter privilege.
Okay.
And I'm, as I was leaving for court this morning, I received a text from Mr. Kearney indicating that he intended to rely for his filing on something previously filed. I unfortunately did not have them with me and have not been able to look at it, but as far as the argument itself goes, I'm more than willing to rest on my filing for the most part, particularly if Mr. Kearney is as well. I'm sure I reviewed that other document at some point, but it's not fresh in my mind.
Okay, so what you're referring to is that there is a taint team that's in place.
There is a taint team in place.
That's Judge Macy, right?
That's Judge Macy is the...
Whoops, mute's on. Let's just start there. There's a taint team in place. This is Judge Doolin, isn't it? Because the other judge recused himself because he's got some sort of friendship with Cosgrove, right? I think this is Judge Doolin. But here's the thing. The taint team was put in place after the due process was violated. They already took his phone. They already read his phone. They already tried to put in place a grand jury to indict Karen and Aiden before the taint team came on board, right? They already tried all of this shit before the taint team. The damage was already done. Like, I don't even know why we're even talking about a taint team right now.
Evaluator, so to speak, of privileged material, what should be turned over and what should not. And Mr. Verino is the electronics expert that would actually do the search. And my problem, Your Honor, is that they fulfilled their part as far as they could by returning within, I think, a week of Judge Krupp issuing the order, their acceptance of the order and the responsibility to undertake that. And as far as I know, the court has not forwarded to them the appropriate search terms. I don't know what search terms Mr. Bradle supplied or
Let me just ask Mr. Bradle. Mr. Bradle, did you supply search terms?
I did, Your Honor. Document 67, I believe.
Number 67. Okay. Have you seen that, Mr. Cosgrove, or is that something that's outside your view?
Well, Mr. Bradle had permission to file them ex parte, so to speak, if he believed that they might disclose something appropriate to Commonwealth.
So you want me to forward that to Judge Macy, to Mr. Verino?
Well, I don't know that I do, Your Honor, because I want you to make an evaluation first of the appropriateness of those terms, which the court is supposed to do under Judge Krupp's order.
Okay. I'll take that. I'll do that myself.
All right. I appreciate that, and I would say if the court wishes to hear further argument, at this point, I would say just forward it all to Mr. Verino, tell him there may be further instructions coming from the court.
Okay.
Because it's been, 4 months now?
Okay. I'll do that. I'll forward it. Okay, I'll take a look at what Mr. Bradle has requested. If it's appropriate, I'll do as you request, okay?
All right, thank you.
Mr. Bradle, anything you want to say on that?
Yes, thank you very much. So, Judge, in document 67, it was just the original filing on this very issue where I asked for this hearing. And so in that case, Judge, there's a 1985 case, which I would kind of call it, it's kind of long, convoluted name. I would just call it the Petition for Protection of Confidential News Sources. It's from 1985, and it's still good law. And it addresses the situation that there's no statutory journalist privilege in Massachusetts, and it says that courts should deal with it on a case-by-case basis, as we are here, of course, and address issues as they come up. And just a quick quote up from the case, Judge, is that this court should consider alternative remedies for compelled disclosure of journalist source material. And my client has informed me, and he has previously sworn in an affidavit in this case, that his phones contain journalist source material. This wide swath of electronics that the government has seized in this case, that there are areas where there are journalist sources. And most alarming, most eyebrow-raising, Your Honor, is that there are some instances where there are sources giving information on these very same state police actors in this case that we have been criticizing and pointing out errors and alleged corruption on. These people are the ones that are going to get this information. It's not even like the FBI or a third party. This is source material on the people that Mr. Carney has been criticizing in the Karen Read case. So I can't think of a more important case where a court ought to craft an alternative remedy for compelled disclosure than this. We have these conflicted officers who have, we contend, perverted the witness intimidation statute for their own goals, and now they possess my client's electronics, and they're going to go through them for source material on their own wrongdoing, their own misdeeds. It's unbelievable. It's like a John Grisham novel, Your Honor. So this court is in a position to say, time out. Under the Petition for Protection of Confidential Sources, I can craft a remedy here. In fact, I think it's the court's duty under the First Amendment in Article 16 to craft a remedy and say, time out. The taint team is going to be sworn in under oath. They're going to provide information relative to the search warrant, relative to the court orders, but they may not provide any journalist source material, in this case, to the Commonwealth. And if there is an issue with any such material, it will be isolated off to the side. The court can look at it in camera, along with the defense, sort of like a Lumen Martin situation, Your Honor, and we can take it from there. That would be my request on that, and I think under that case, that would be the appropriate remedy for the court to address it.
Okay.
Thank you.
So ruled. That's what I would do. Because this court has already violated his rights. This should be part of fixing that problem, right? That should be, so it should be the remedy, is what I'm saying. Allow them to do it this way. That's what the remedy should be.
That's all. Thank you.
I got it. All right. Yeah, no, go ahead. Go ahead.
First of all, I heard Mr. Bradle say that Mr. Kearney has produced an affidavit claiming that journalist sources are contained within these electronic devices. I don't claim to never miss something, Your Honor, but I don't think I've seen it. So I would ask for some specification of where.
Yeah, Mr. Brado, is that part of in-camera Exhibit A? Judge, I can't tell you off the top of my head. I want to say it's probably 30 or 40 documents ago, but I'm happy to get it to everyone when I can get to my files.
Okay, that's fine. Why don't you do that? Why don't you send a copy to Mr. Cosgrove and send a copy to Attorney Sano?
The second thing I would say, Your Honor, is that, and I'm not necessarily opposed on principle to making new law, but I think I'm correct in saying that if the court rules that the taint team screens for anything other than attorney-client privilege, it would be the first case I am aware of in the United States that has ever had that holding. And I think it would also be the first case where the so-called
they already did Cosgrove
has not yielded to the demands of and the interests of the government in terms of vindicating search warrants and criminal warrants. And finally,
oh my God, don't act so innocent. They already did it. It's already been put before a grand jury. They already done it. This is past tense. The first case you ever heard of. Oh my God, it's so frustrating, right? Grr.
If I could, Your Honor,
no, go right ahead.
Judge Krepp's order also set a time, I believe, for Mr. Kearney to provide the Commonwealth with the passwords to these electronic devices. And I don't know whether there's been a formal answer on the record to that.
Let me ask Mr. Brado. Do you have a response to that? About Judge Krepp's order?
About passwords, Your Honor?
Do you know what paper that was, Mr. Cosgrove?
I'm afraid I don't off the top of my head.
All right. So what you're saying is that there's an order from Judge Krepp that orders Mr. Kearney to provide a password to the device?
Yes, it's set out in the procedure of Judge Krepp's order.
All right.
And, you know, I don't know if well, let's put it this way. If Mr. Kearney has already provided that to the court, we need it, or rather Mr. Verino needs it in order to feasibly open the devices. If Mr. Kearney is contending that he's forgotten the passwords, you know, we need to know that so that Mr. Verino can proceed under what measures he can to crack the devices without the password. Or if Mr. Kearney is maintaining that he has a Fifth Amendment privilege against disclosing the password, then I think still I would tell Mr. Verino, or ask the court to tell Mr. Verino, that he may proceed. Well, proceedings are underway here. But I would then file a motion to have the court adjudicate whether he in fact has such a Fifth Amendment privilege.
Okay. Mr. Brado?
Yes, thank you, Your Honor. So at this time, we're not pressing any Fifth Amendment issue. My remembrance of the case on that is not, it's not particularly solicitous.
No, I agree. Yeah, I think that there's a case on point from the SJC.
Right. But, Your Honor, some of those devices are pretty old, and some of them are old and not Mr. Kearney. So there's some issues there. What I would suggest on that is that if there is, I happen to know that the state police do have at least one, if not two, of the passwords of the devices that I think they're primarily interested in. And my thought is that they can report back if they have any issues, and we can take it from there.
Okay.
Is that right?
That's not the order. The order is that he's to turn over the passwords.
Right. Mr. Brado, have you responded to that in any way? Have the passwords been turned over? Is there...
Judge, I think that...
This is so stupid. Like, sitting here arguing about passwords when we know that the kit that comes with Celebrite can actually crack into the phone without a password. They already did it. This is such a stupid waste of court time. They've already done it.
I mean, if I don't, obviously, as you both know, I've come into this afternoon after one of my colleagues has been recused. So I'm trying to just kind of narrow the issue here a little bit.
Sure, Judge, we're not opposed to doing that. My thought was that we were resolving this stuff, and then once the court was giving the green light to the taint team, we'd be happy to do whatever the order said.
All right. Okay, I get it.
I just was sort of chronologically looking at it as this was the next thing, and then we'll be happy to comply with whatever the order is.
Well, you already got an order from Judge Krepp, so what I would suggest is I'll give you 10 days to comply with that, okay?
Okay, thank you.
All right.
So essentially, oh my God, I waited for him to finish the sentence, and then what I was going to say fell out of my head. Essentially, I think Radel is doing this so that it doesn't get disclosed to the public, so that his private calls and whatever don't get disclosed to the public. That's the only reason Bradel's doing it at this point. And it's because it's Aiden's right to as well. But some of the phones aren't his. There you go. I didn't know that. Yeah, I don't know that I believe too much of what Guarino says, but Kevy, unmute yourself and tell me. Tell me all about it, buddy.
Yeah, Guarino had said on the stand when he was laying the foundation for his knowledge and experience about how long it takes to crack into a phone. If it's like a 4-digit alphanumerical passcode, it takes X amount of time. But if it's a 6-digit or if it's an 8-digit, and depending whether it's using special characters, and he explained how many calculations, possible calculations could take to figure it out.
He's lying. They actually can get straight into the data without any of that. So, but I would do a video on that. I would do some more research on it, because it could be me speaking out of turn.
That'd be interesting, yeah. Because Guarino's the last person on earth I'd believe about any of that stuff, but...
Right. He's still trying to make it sound like, it's still got to go through. Here's the thing, to crack what he's saying is true if you're cracking a password.
Yeah.
But if you are just going straight in the back end with devices, you don't need the password. So, but yeah, I'll look into it a little further, because I'm pretty sure that there is some mechanism.
But
there is some tool.
If that's the case, why were the American government pushing Apple so hard for a backdoor into the iOS system?
For this reason, because they couldn't brute force it.
Right. Okay. Yeah, but what I'm saying, you're saying Celebrate can get in the backdoor.
Right, because Apple ended up folding.
They
ended up giving them a backdoor.
I didn't realize they did. Okay.
Yeah.
Thanks, Joanna.
Next thing, Mr. Cosgrove.
I am agnostic, Your Honor, as to whether I would yield to Mr. Moreno's preference as to whether he wants to go forward on the bail revocation motion, or whether he wishes to press his discovery motion at this time.
Okay. Judge, I'd like to hear on the motion to compel.
Okay. The motion to compel. Go right ahead, Mr. Brett.
Thank you, Judge. I'm not going to belabor, I'm not going to just repeat the written filing, Judge, but it's been a long time. There's been many discovery orders in the case. One comes to mind May 8th from Judge Cahillane of last year, and still here we are. And there's also, if I may, Judge, there's some qualitative issues that we have as well. We've gotten screenshots of text messages, very important text messages, and that is just not an adequate measure of compliance with providing text messages, Your Honor, because you don't have the whole string, you don't have the metadata, and something that just occurred in the Karen Read case the other day, excuse me, was that a witness named Kerry Roberts took screenshots of her text messages that were provided to the defense as screenshots, here, same exact situation as we are here, and did not, in my opinion, give good faith answers to foundational questions about whether they were her text messages. And these text messages were not admitted. So here we are. And that's a perfect example of why screenshots of text messages are not something that ought to be satisfactory. So we need the digital copies of these items. They're ordered, they're supposed to be given, and these sort of piecemeal pieces of paper with no foundational support, no assurance that it's the entire string, and they're really not the entire string. These really need to be given to the defense as a matter of due process, Your Honor. And I can say the cases, but you know them.
Okay, let me hear from Mr. Cosgrove on that.
Before I get to that, Your Honor, I would like to address a few things.
That right there, exactly.
I would like to start with the affidavit that has been submitted in support of the motion.
Okay.
Has Your Honor had an opportunity to review that?
What paper is it? There you go. Let me see. Yeah.
Well, let me see if I have an
Oh, yeah. Okay. I'm familiar with that.
Thank you. I know Your Honor looked at it and entered a preliminary order allowing a motion for impoundment, but pending today's proceedings. And I want to place the court on notice that I object largely to the order of impoundment. I don't object the impoundment of the name of the witness in item number 8, who is allegedly described with an obscenity, although that is the least of the characterizations of his behavior, allegedly described that way by Ms. Peter. But I do object.
The most trustworthy source on the planet.
What in effect, for the record, would be an anonymous affiant. I particularly object to that because before the ink was dry, Mr. Kearney essentially outed the name of the affiant in his own YouTube presentation, and her identity was discerned by Ms. Peter the same day and was the subject of an extensive post on YouTube. So there is no purpose at this point, Your Honor, to allowing her to pretend to hide behind an impound.
Okay, I got it.
Moving on to that, Your Honor.
I just have to wonder if Cosgrove's taking into account that Kate Peters went to her house and pinned rat on her face, on her door. I don't think Cosgrove's taking that into account. Secondly, he does realise that Kate Peters been now named a state agent, right? Like an agent for the state. Funny.
I object to the affidavit. I think that Mr. Kearney should produce the affiant, or that the affidavit should be stricken. This affidavit largely recounts purported hearsay by Ms. Peter, and I'm not going to go through them all one by one, but I will say, for example, that the assertions set forward in the affidavit are so preposterous and outlandish on their face that I really, I don't mean to be overly critical of brother counsel, but I really question the judgment of counsel for Mr. Kearney in going forward and filing. For example, if Your Honor will look at item 6, supposedly Ms. Peter said, and the affiant repeats it as gospel, that at one point in the jury deliberations, Ms. Peter met with a prosecutor for lunch. And that during the lunch meeting, doesn't say where, it doesn't say when. During the lunch meeting, the prosecutor was indiscreet enough to tell Ms. Peter that he knows the foreperson, who is a retired police officer, and he, the juror, is guaranteeing a mistrial. Now, does that make sense to you, Your Honor, that an experienced prosecutor, and I don't know if the named prosecutor has appeared in front of you or not, or has an impression of his, you have an impression of his ethical qualities, but he would have to be both unethical and stupid to both engage in this kind of jury tampering, and something else you can call it, and essentially contacting a juror to fix the outcome of a jury trial, and then turn that information over to a woman who is a known YouTube blogger. That's one. In item 7, she indicates that she, Ms. Peter, is paid $1,500 each month via Cash App for her assistance in Karen Read and aiding Kearney prosecutions. Well, I'm tempted to make light of this, Your Honor, and say that if the district attorney is paying Ms. Peter that money, he's not getting his money's worth, because I haven't heard from Ms. Peter in the entire time that I've been representing the Commonwealth in this case. But put that aside. Cash App has records, as I understand it. It has records from what bank account to what bank account. I don't know what Mr. Brado did to verify this, but I don't see any records from Cash App, and I would like to examine this call Antonio, excuse me, so far it's still in the pound, but I guess I did about the 9 million person to let the name out of the bag.
I knew that I'd be straight.
Okay. Go ahead, Mr.
I would like to examine the affiant as to that information and what, if anything, that she did to verify. The affiant then says that she personally has heard Ms. Peter on the phone with Hank Brennan, that she personally recognized Hank Brennan's voice, that Peter told him that her people leaked it to the media, referring to the federal investigation being over. I think the people who, putting aside the fact that I think the person who leaked it to the media effectively was the U.S. attorney on a radio interview who responded to the question of whether she had communicated with the Commonwealth or the police department as to the progress of that investigation, by saying she couldn't verify whether a grand jury investigation was over, but that it would not be uncommon for her office to communicate with law enforcement, et cetera, et cetera. Anyone who had any sophistication knew what she was saying, and about a week later, the district attorney's office verified in open court that that was the case. So I don't know why we needed Ms. Peter to leak that to the media when we were announcing it in open court. But at any rate.
Yet she did leak it, didn't she? So I just looked up, oh my God, it went fucking blank on me. So I just looked up about the Cellbrite stuff. I'll come back to it because the page has gone blank. It's going to reload. Let's play a bit more of this while I wait for it to come back.
I would like to examine the fiance as to how she knows Mr. Brennan's voice, how she knows about these multiple conversations, when they took place. And finally, I'll skip over the rest of them for the most part.
How does she know Brennan's voice?
Items 13 and 15,
Same way we all do, Cosgrove.
in which Ms. Peter informs her that Jennifer McCabe bought her a brand new sectional, I assume she's referring to a sofa, as compensation for her assistance. I'm not quite sure how Ms. Peter has assisted witness Jennifer McCabe, but maybe it's revealed in the next section where section 17, where Peter informs her that Jennifer McCabe paid her for her show of support. Well, subsequently know that apparently the affiant lives in the same apartment building of Ms. Peter, who has not denied in her own posting that she knows this particular witness. And presumably she knew that Ms. Peter had a brand new section. I suggest that the information that Jennifer McCabe brought her a brand new sectional is made up out of whole cloth. And I'm not going to go through it all because I'm hoping the court will give me an opportunity to examine this witness in the witness stand. But I think the court could ask itself why this particular affidavit is being submitted now in support of what I would suggest would otherwise be a fairly routine thing that comes before judges, motions to compel discovery.
Okay, let me get from this. I'm sorry, let me cut you off.
And I suggest that the reason is this, and the court can make its own judgment. And my assessment is that the purpose of the motion is to dirty Jennifer McCabe. I don't think it's an accident that Jennifer McCabe was testifying today in the other courtroom and yesterday in the other courtroom. And I suggest that the purpose of this motion, which has been loudly termed...
Jen McCabe has entered the chat. Why are they even bringing up Jen McCabe in the other courtroom in this hearing? So much shady business going on.
By Mr. Kearney on his YouTube show was to accomplish his oft-stated purpose of prejudicing the jury in that trial.
Let me just talk to the attorneys inside.
Kevy, I'm just going to let this play for a second. I just got to quickly run outside and do a chore and I'll be back. It's just going to put my bin out. So I'll be back, but I'll just let this play out a bit.
Mr. Cosgrove, the floor is yours.
I will stop at this point unless anyone has questions.
That's fine. All right, Mr. Brady.
Thank you, Judge. So, Judge, a lot to respond to. First of all...
Why was that affidavit attached to the motion to compel?
Because, Your Honor, that's the basis to show that this information exists. The Commonwealth has not provided any of those things related to Kate Peter. And my colleague, Mr. Beverly, who I know is watching here from New York, he wrote a letter to counsel for the Commonwealth in, I want to say, October of 24. That was the first of his 3 letters that he wrote, pointing out all kinds of these things. Ms. Peter has been under oath at other hearings, my client's restraining order hearings against her, where she has said under oath that she's cooperating with the Commonwealth. She has said it many times online that she's cooperating with the Commonwealth. To this day, our third motion to compel, discovery orders, the discovery was due a year ago, Judge, and we still have nothing. And so this woman came to us, Judge, April 21, Patriots Day, came to us Monday, April 21, and we did what a lawyer needs to do in that situation, which is we memorialized it, she signed an affidavit, and we submitted it as further proof upon Mr. Bedro's letter that this information exists. And now we have it from the horse's mouth, Your Honor. So that's the answer to your question. This woman is saying to the affiant that she is working with the Commonwealth, giving all these details about making money, about meeting with these people, about receiving funds. A lot of this has been corroborated by other people on the internet as well, Your Honor, which we're in the process of gathering up. But this affidavit, Judge, was submitted for Mr. Carney. It's got nothing to do with the Read case. It has information in it that's important to the Read case. We are not the Read case. I am here today defending Mr. Carney from these scandalous allegations that just absolutely seek to destroy the First Amendment in Article 16.
Okay, so what's the discovery that you want compelled?
So, Judge, I want all the information from this affidavit and from our motion to compel about Kate Peter. She's a government agent. If this is all true, Your Honor, the DA's office is paying a third-party witness to intimidate witnesses in the Karen Read and Aidan Carney case.
So what? Maybe we should hold a hearing on that. Okay. So I'll take this under advisement.
Thank you, Your Honor.
I'll come up with an order as to how we should proceed on that.
Thank you.
Now, as to Mr. Cosgrove, are there any other issues that you see? Any other motions that you want to bring to my attention? I know that I received a thumb drive earlier today that I've had a chance to review, and I'm sure Mr. Bradel has a copy of that.
Yes, I provided Mr. Bradel with a copy when I saw him earlier this morning. I don't know that he's seen it. I would like to play it for the court if I could.
Yeah, no, you can play it. So, Mr. Bradel, this is Mr. Cosgrove's motion to have your client's bail revoked, I guess.
Yes, sir.
Okay.
If I may, Judge?
I'm going to start with Mr. Cosgrove, then I'll go over to you.
Thank you.
Go ahead.
As Your Honor may know, I'm pretty much a computer illiterate, but unfortunately, I have to say
Mr. Bradel, you want to come up?
Sure.
Forgot about the mute button. What did I miss? Anything important?
Not a lot, just a lot of white noise, really.
Yeah. I had to run out there and do the rubbish quickly. Our rubbish truck can't turn around down this end of the street, this end of the road. So we basically have to pack our bins up and take them up the other end of the road to meet the rubbish truck. And for some reason, they're doing it early. All right.
Yeah, they were discussing. Kate Peters there and the affidavit and discovery issues.
Yeah, well, Kate Peters screwed up her own case because she pinned bullshit on their doors. Let me show you the picture for those who haven't seen it.
Cosgrove was trying to say that Kate Peters was unreliable, didn't know what she was talking about, whereas Bradel was saying that she's testified before the judges.
Yeah, as a state witness, as a state agent.
That she's cooperating with the Commonwealth and stuff.
So, I mean, this is what she did. She pasted rat across the girl's face. So if you're claiming that she lied, why are you calling her a rat? Shouldn't have had anything to rat you out for, right? If you didn't do all of that stuff. And pasted all of her criminal record on her door, like as if she doesn't know. Plus, she's forged letterhead, called her most wanted, which she's not. Like the cops don't know where she is. But anyway, that's what Kate Peters did, which is very telling in my book that, she thinks this girl's a rat. And if she had been telling lies, she wouldn't be calling her a rat, would she? Anyway, there's that. Where did the YouTube go? Hang on.
Where you left it, I suppose.
Yeah. Did I move off of the YouTube? No, I didn't. Wow, that's confusing. It's got my icons mixed up at the top. It's showing me a YouTube page for the X page. I was just
cheap.
Oh yeah, because it was on my freaking. I got it. It was on my YouTube account. All right. I just wanted to go through Aidan Carney's devices. So in that little bit of research I just did, I just realized something. I think that they didn't actually crack his password. Okay, they didn't get as much information. Someone actually mentioned if they don't crack the password, they can't get as much information from the phone, right? I forget who that was,
Yeah.
but thank you for who said that.
I can find it for you if you want.
Yep. Who was it that said it?
No word salad.
Okay, no words valid. Thank you for that tip because that put me onto something. So what let's talk about the two different systems, okay? It turns out that iOS is actually the more secure one. They still haven't given into the feds yet. It's Android that gave into the feds. So I was
wondering. I hadn't heard about Apple giving in.
Right. So Celebrite's brute force tools, what do? Their advanced services use brute force, dictionary, or smart guess attacks on locked devices to A, crack passcodes or pins, B, bypass lock screens in some Android versions, and C, extract partitions and decrypt file systems. This is usually done with a physical access technique. Can you mute for a second, please, Kev? Sorry. It's hard to concentrate when I can hear all your stuff going on. This is usually done with a physical access technique. The device is connected via USB to the UFED or advanced extraction kit. So on iOS devices with a passcode, if the device is locked and encrypted, data can't be accessed unless they crack it. The Apple encrypts the file system with a key that's protected by the passcode. So brute force is often futile if the device has a strong alphanumeric password, security enclave, or a 10 attempt wipe enabled. So if they try it more than 10 times, it will wipe the phone. If they do crack the password, they can fully decrypt the file system, access all the user data, including deleted files, charts, GPS, keychain, etc. If they don't crack it, at best they may have limited device info, like the device type, the iOS system, and the last boot time. Nothing that they really want, nothing that they could take to a grand jury, for example. On Android devices, it's a little bit weaker, but it depends wildly based on make, model, and the operating system version. So Androids are definitely much weaker depending on those things. So with a passcode, a Celebrite might bypass Android screen lock by exploits without cracking the password. This depends heavily on the model and the patch level. Some devices are store encryption keys in trusted execution environment, or TEE, or hardware-backed key store, which makes brute force nearly impossible. But if they do crack bypass or crack the password, they get full access. If they don't, then partial access is possible, especially on older phones. So you can get access to some encrypted partitions and some limited artifact metadata like clouds or token access, depending on the method that they use. So Android in this case is definitely the least secure. So in actually researching that, I found out that the Commonwealth already extracted the data from Aidan Carney's iPhones. We know that because he took it to a grand jury. They didn't take the iOS model and basic information off that phone to a grand jury to try and indict him for witness intimidation. They obviously got more from that phone. They used it in their effort to indict him and or tie him to the Karen Read case. And they presented this data without defense access to chain of custody or clarity on whether a taint team reviewed it. We know that because they're now asking about the taint team. So this was all the taint team conversations came up after they already tried to indict him with that data. So we know they got in there. We know they've got the data. So anyway, this all this post hoc discussion about the passwords, it's really just it's what I've already described as laundering the wrongs that they've already done. They're laundering it. So now they put the taint team in place. They make it look like they did it the right way, whereas they never did it the right way in the first. It was already tainted material to begin with. So now they're laundering it to make it look like the data can be done this way, and now it looks clean. But the fact is, it's still dirty. It was dirty from the minute they extracted it and used it in that grand jury indictment, attempted indictment. So it's a legal dumpster fire, because if they already access his phones without a taint team, they can't unring that bell. That's already been done. Whatever comes off of Aiden's phone, anything they think they can indict him for, he's straight to appeals court and back out again. It's overturned because they can't unring that bell. They've already done the damage. Anything from that extraction is tainted. If they didn't have a warrant specific to all areas of the device, like messages, drafts, cloud keys, etc., suppression arguments could apply. So we do see some suppression arguments being requested by Bradel here. So that's interesting. Asking for passwords now implies they didn't get everything during the initial extractions. What they did get was enough to go into an indictment, but it sounds like what they didn't get was the tokens, the keychain passwords to decrypt his Signal app. That's what it sounds like to me. They want into the Signal app, and they haven't actually got access to the Signal app stuff. So it sounds to me like they brute forced it. They guessed his password through the brute force mechanism of what Guarino was talking about. That's the one way to do it. Sounds like they did that, but in that particular method, you're still not getting access to the decryption code to decrypt Signal. But they have got access to decrypting the phone, if I'm making sense here. I hope I'm making sense here. And obviously they know that the first extraction doesn't hold up to scrutiny because they got it illegally, essentially. So grand jury taint. If tainted data was used to indict or guide an indictment, that could be grounds for challenging the validity of any of the proceedings that follow. So like I said, he's probably going to get anything overturned that they might manage to do in this court, especially if Carney wasn't warned or given a chance to assert privilege. You don't get a do-over with a taint team after the fact. It's like robbing a house and then asking the court to approve a search warrant because you found something juicy in the loot. Or they think there's something juicy in the loot. So that's the bottom line. I think they did get into his phone. I think they may have done it using Grey Key for the eye. Oh, there's different tools. There's lots of, but Celebrite has their own. Grey Key has their own. They're different companies, but yeah. But I was under the impression that there was a physical plug-in type interface, and it might be the Grey Key that I'm actually thinking about that bypasses the password. But it seems that I was wrong. It's not necessarily Celebrite that has one of the has that feature. It could be Grey Key. But at the end of the day, I think I worked out that they got all the data because they took it to a grand jury and tried to indict him. Could be Axiom, Kevy, I'm not sure. They did definitely get some data. They took it to a grand jury, but the data that they want now, that they're crying about now, is the Signal app, because that's how he communicated with Karen Read. So all these trials that have been held in this courtroom where he's in right now have all been in relation to his Signal app communications with Karen Read and her defense team. It's encrypted, so there's that. And secondly, I'm pretty sure Signal actually deletes it after a period of time. Like, I'm sure they've had this stuff for a couple of years now. Pretty sure Signal actually deletes shit after a certain period of time, doesn't it? Let me ask that question. Everything's going slow on my end for some reason. I'll tell you the answer to that in a second. So obviously there's more of this to go. Yes, she took a photo of her work and shared it. Are you talking about thank you, Nightbot? Wee woo, wee woo. Obviously you guys could hear sirens in the courtroom. Do we know Krusty did it? Yeah, she took a photo, right. And here's the other way we know that Krusty did it, F-bombs, is that she lives next door. So her apartment, Krusty's apartment, is right next door to that girl's apartment. So who's got access to that hallway? Obviously Krusty. So I reckon they want Signal too. They want Signal app, just because they've been raving on about Signal app this whole time, like with all of this stuff to do with Karen Read. So Signal has a disappearing messages feature, and it can absolutely nuke your chats on a timer, but it's optional and user controlled. So he no longer has the phone in his possession, so he can't control it. But the timer can be set to 30 seconds, 5 minutes, 1 hour, 1 week, or a custom time frame. So it could be months. So once enabled, messages self-delete after the timer runs out, starting from the moment they're seen. So then they literally have to turn the phone back on again to activate the timer in the software. If they're just doing this through Celebrate and extracting the data and not necessarily getting into the phone and activating Signal for it to execute the timer, then they can actually freeze it in time so it doesn't execute the timer. What else does Signal do to keep your combos private? End-to-end encryption. So when they say end-to-end, that means that Signal end, there's an encryption algorithm, and then on the device that's doing the communicating is the answer, just to keep things simple for you, is the answer to that algorithm. And when the question and the answer match up, that will decrypt the messages. So no cloud backups unless you export and store them manually, and no message history on Signal servers. So no cloud history there. And the app even warns you if someone takes a screenshot on Android. So there you go. But here's what it does not do. It doesn't delete all chats unless you set that specifically. It doesn't scrub unencrypted notifications if your phone lock screen preview is enabled. And it won't wipe message history. If a forensic tool got to your unlocked device while Signal was still running, and rooted or jailbroken access was possible. So there you go. Those are the limitations. So crazy, right? So that's why I think that they're first of all, they're trying to launder the data so they can use it against him in court. They're going to clean the data because they've already tainted the data. So that's what the first thing that they're trying to do here. And then the second thing is they're trying to get into that Signal app, because the one thing they want is to revoke Karen's bond and make Karen look even worse than they're already making her look, basically, with Aiden's tax. So If you have an extra app, I've never used Signal, so I don't know the ins and outs of it. If you have an extra passcode for the Signal app, so you have your passcode on your phone, and then you have the passcode for the Signal app. That's what they're asking for, the Signal app passcode. Oh my God, that makes more sense now. Because we know they cracked his password to be able to show the grand jury anything for an indictment. I think you hit the nail on the head, quality emerald. If the Signal app has an extra passcode, that's what they're after here. Bingo. Thank you for closing that loop for me. Wonderful. Let me just add some comments here. Let's see. I'll give you an answer in a second. All right. MSP mainly use Celebrite and Grey Key. Yes, Grey Shift is the Grey Key tool. Right. It depends on which model of phone they're trying to crack, because they each of them have their own features that one might be better than the other depending on the model of phone they're trying to crack. It's particularly effective for brute forcing passcodes with claims for unblocking. This is the Grey Key. Grey Key has been noticed in use by various US police departments, and its adoption by Massachusetts law enforcement is likely given its prevalence in major departments. Yes, Australia's big on Grey Key too. Celebrate and Grey Key. All right, so let's get this answer up because I want to know more about Koberger with Snapchat. Yes, he was. All right. That's exactly what this smells like. Signal has 2 layers of protection. Device encryption, like your iPhone screen lock, passcode, or Face ID. And then your Signal app PIN or registration lock. So even if the police use Celebrite or Grey Key to access the device by brute force or bypassing the iOS lock screen, then they cannot extract things like Signal. They're still starting a locked vault inside the vault, basically, if Signal has its own PIN or registration lock enabled. And knowing Carney, he probably does have a PIN on it. So they've already tried to indict Carney based on data they got, presumably photos, texts, maybe from less secure apps or metadata. Now they're trying to retroactively justify what may be a shaky legal grounds extraction by forcing him to cough up his Signal PIN or any missing encryption keys or backup files, secure apps, or folders. And it's all sketchy as hell. If they already used his phone data in that grand jury last March. Sketchy as hell. Sketchy as hell. Yes, Signal has a lot of benefits, Kev. It does. If Carney asserts the Fifth Amendment, he can't be forced to give up his Signal PIN. If doing so would be testimonial. If it reveals something only he knows, that would be testimonial. The case law on this is murky, but it's been fought before in a crypto key and password cases. So yes, this looks like they cracked the phone open partially, got some low-hanging fruit, but now they want full access to the Fort Knox inside the phone and signals sitting there flipping them the bird with AES 256 encryption. That's funny. That's actually Chat GPT with a sense of humor. So they both do it. It's just that one's better than the other. So they both have password crackers. They both have brute force password crackers. So you have to remember that Grey Key is in competition to Cellbrite. So if Grey Key can crack passwords, and Cellbrite's obviously got to do it too, because they're in competition to each other. So it's not that Grey Key is like a complementary software to Cellbrite. They're actually competition. So they both do the same thing. It's just that depending on the model of phone, some Cellbrite supports some models of phone better than others, and Grey Key supports other models better than Cellbrite. So they just use them interchangeably depending on what they want to do and what the latest update for the software is allowing them to do. So National Security Edition, right. I would give them a neodymium disc and tell them that will get you into my phone as soon as you attach it to the back. So I mean, these guys at this particular police force are particularly easy to trick, right, into doing stupid shit, because they're just stupid. I'm not sure. Do you want me to ask? Hang on. It's a good question, bud, isn't it? It's a good question. Let's ask it. I'm going to ask it exactly the way you have written it. I'll tell you in a second. I think if you got a new phone with the same number, the Signal app, then the app will automatically disconnect. We shall find out. We shall ask. Mandy, good to see you, hun. Let's see what the answer is. Ugh, it's all choking up on me. So when I ask too many questions in the AI, it gets all choked up and takes ages to answer. So still waiting for an answer on that. But I really think I'm going to leave it up on the screen so that we know what it is that we're doing, because this is likely to take so long I'll forget what the frigging exercise was. So let's watch a little bit more of this and see where we go. See where we go with this while I'm waiting for an answer.
Yeah, I was on. Who was that? Tell me who Garino is.
He's a trooper in the Karen Read case, and he's an electronics expert that's...
No, he's not.
Did the analysis of the two devices of Mr. Kearney's that were...
Dude, an expert doesn't say, oh no, I don't know how SQL databases work. That's over my head. That's not an expert. That's just a dude who knows how to operate Cellbrite.
They were already searched, and that aren't really the subject of this whole painting thing. I also did the analysis in the other case that he mentioned and has been defamed as supposedly missing all kinds of communications, which is not true. He was, as is alluded to, in an unfortunate car accident that we hear Mr. Kearney taking pleasure in. So let me start with a couple of things, Your Honor, if I could just have a moment.
Yep, take your time.
Having had to put this together at the last minute because the presentation just came to my attention the other day, I didn't have directly in front of me the orders that Your Honor entered, although I think I summarized them correctly in my memorandum. But as I understand it, according to the docket, on March 5th of this year, after I initially brought this to you.
All right, we'll come back to March 5th, but holy fucking shit, you just opened up a whole can of worms, Teacup. Teacup brought in the Kraken. All right, this is interesting. Aiden can change what's in his current Signal account or app, and that affects what they'd get if they ever get access now. So if they're trying to get it off the phone still, then yes, he can change what's on that phone, because as soon as it boots up, it connects to the server, it goes to the current information. Now I get why they're trying to stop it. Now I get where Bradle's coming from. Okay, so that part he can do. He can't retroactively wipe or alter what was already on the old device. So if they just took the image of the device, it's frozen in time. They imaged the device before, Aiden did anything else in his Signal app. So if they're just talking about an image of the device, which we know they're not because they're asking for the password. We know they're talking about accessing the phone again. But if it was just an image, then that's frozen in time. That can't connect somehow to the cloud and update according to what he's got in his current Signal. But if they're trying to access the actual phone, I think they actually can get into his cloud backups, which will indeed reflect what he's done on there since they took his phones. So that's interesting. He can change the settings now, including setting messages to auto-delete after 5 seconds, deleting individual threads or media, and locking the app tighter. But unless they get his device and crack it, they're out of luck, especially if he's using a registered lock pin, disappearing messages, strong local encryption, or even reinstalling Signal to generate a new encryption key. And that's what I think would happen on your new device. You would get a new encryption key. So they would actually need his current device or access to his cloud. So that's interesting, Teacup. Very interesting. The taint team or a judge compels him to unlock current devices or reveal Signal credentials. If they do that, then they're trying to fill gaps left in the earlier extraction. Obviously, they didn't get access to the Signal. If he wipes conversations or sets shorter deletion intervals since then, too bad for them. But if they can compel him to unlock Signal and the chats are still there, then that data becomes fair game. So I'm pretty sure Aiden learnt some lessons when they took those first phones and locked shit down pretty tight. So data on the old phone as an extraction is static. That can't go anywhere. It's exactly how it was when they took the extraction. Data on his current phone is dynamic, and yes, he could nuke it or change retention, and that could affect what's on the cloud, what's stored on the cloud. So, interesting. Either way you look at it, it's still an evidence do-over, right? If they are separate passwords, they need to subpoena the Signal password itself. I don't know how that works because I'm not a cop or a lawyer, but I would imagine a warrant for the phone data would cover all of the phone data. Just me imagining. Might not be true. So, let's continue with what happened on March 5th.
The docket entry records that the court orders defendant to have no contact, direct or indirect, through third parties with any of the witnesses or victims in this case, and 2, stay 100 yards away from any victim's residence or place of work. Defendant dissents. Bail warning read. Now, as I recall, that was sort of a provisional order, and at that time, even more so than today, I had just got the information relative to Mr. Kearney's antics outside D&E Pizza in Canton. Mr. Bradle hadn't really had time to absorb it. I didn't have police reports to give him, so Your Honor may remember that you put it over to the following day for hearing. After hearing that day, the docket reads as follows. Additional conditions of release. 1, stay away. No contact, direct or indirect, with the named witnesses in his Superior Court cases. 2, stay 100 yards away from D&E Pizza in Canton, Mass. 3, behave in an appropriate manner while in any courthouse or within 300 feet of the building. Defendant dissents. Bail warning read. So with that clarification, Your Honor, I'd like to begin. We indicted Mr. Kearney because in our view he was engaged in a campaign of intimidating the witnesses. After we indicted him, one of those methods he essentially ceased, and that was leading parades of automobiles outside witnesses' homes and places of business. But he did not otherwise decease. So what we have here, Your Honor, is the most extreme recent example of Mr. Kearney's behavior. And if I wanted to bring these to the court's attention, I could probably do it about 4 times a week. But just to give you some other examples, if I might, of Mr. Kearney's latest hits.
Go right ahead.
Within a week or two of the last time I brought his behavior to your attention, he was on a live broadcast mocking Elizabeth Proctor, a witness in the Read case, for thinking she was blue, unquote, or a member of a blue family, because family members were police officers, and because she gave oral sex to her husband, who was a police officer. And he went on in the oral sex thing for some time. One can imagine the effect that that has on a witness, knowing that she's being humiliated in front of hundreds, perhaps thousands of people.
Dude, that's satire.
Dealt with by the court.
Yeah, he's giving me some history, so it's overruled. I'll listen to your recitation.
I informed the court the last time, and the court viewed it, of his show-up and antics before the Albert's Pizza Shop. I had personally routinely heard him refer to the presiding justice online of the Read trial as a cunt. He engages in constant defamation, for example, of Jennifer McCabe as a murderer, and he has described the others as murderers. And in general, he is aware and has remarked, I think this is another thing I brought to Your Honor's attention the last time, has remarked with satisfaction that the results of his broadcast have made it difficult for these people to go out in public without being harassed and without being mocked. I would suggest that Mr. Kearney wanted this communication to be conveyed to Lieutenant Tully, knew to almost a certainty that Lieutenant Tully would see it, wishing death in the most horrible fashion to him and his wife, and knew that that would excite others of Mr. Kearney's followers to pile on, so to speak. I'd like to introduce an exhibit, Your Honor. I provided a copy to Mr.
Wait a
Bradley.
minute. Dogpiling has entered the chat. Now he's talking about dogpiling.
I'll give him an opportunity to object, but I would suggest it could be marked for identification.
Yeah, we'll mark it for identification.
And,
you could just...
Mr. Bradley wants to object.
Okay.
I do that, Judge, based on relevance, materiality, foundation.
Would you give us a minute? Okay.
Thank you.
All right.
And just so we're clear, I don't even think the Commonwealth is suggesting this has anything to do with Mr. Kearney sending them. Which, of course, it did not.
Well, I'm happy to agree with what Mr. Bradle...
We'll mark it for
with what Mr. Bradle just said, Your Honor. Okay. But it is always Mr. Kearney's response that when these witnesses are deluged with harassment immediately following his broadcast and thereafter, that, oh, of course, he had nothing to do with it. He didn't send it. But he knows what happens. And I would suggest to you, Your Honor, that this is relevant, not because Mr. Kearney sent it, but one, because the court could conclude that it was a logical outcome of the kind of scorn and hatred poured out upon Lieutenant Tully and his family. And two, that Mr. Tully, Lieutenant Tully, who was well familiar with these reactions.
Lieutenant Tully is the one that arrested him at his kid's school bus stop. Of course he's got scorn and hatred for Tully. Like, hello? Jesus Christ.
On reading, or listening to, or being informed of Mr. Kearney's broadcast, could reasonably fear reactions from these sort of nuts directed at his wife and family. And I suggest that his reasonable fear is evidence of intimidation of the witness. And on that basis, Your Honor, I would ask that it be marked as an exhibit.
Yeah, we'll mark the disc as the next exhibit.
And I would further ask that it be impounded, because I don't want the comments made in that. I'll get to the very end.
Yeah, I'll impound it. Mark it. Here's the disc. Yeah. Yeah.
So I don't want to belabor this, Your Honor.
Can I just go back to Attorney Crespo?
Yes.
As to Exhibit A, could you explain that to me a little bit more?
The one you just marked?
This one right here.
Yes. At about whatever time is indicated on the top of the email, I received that email from Lieutenant Tully indicating that he had received that communication from this person, who, so far as I know, is unknown to all of us. Whether his identification is genuine or pseudonymous, I have no knowledge, and that he received it through LinkedIn. And that's about all the background that I can give you.
To your knowledge, though, this says, well, strike that. What's the
To my
relationship?
knowledge, I do not allege that Mr. Kearney personally sent it.
Okay, I guess that's what I'm
I
asking.
allege, number one, that it may well be, one could infer reasonably that it is the result of Mr. Kearney's broadcast.
Okay, I get you.
And two, I infer that, one could infer that Lieutenant Tully reasonably anticipated these kinds of things.
So he's going for incitement to violence. That's what he's going for. That's what he's suggesting here, which is a federal offence, actually. I think.
You know, I don't know if this nut is going to be motivated to go out and try to assist in a car accident or in burning things down. And you know, when somebody says to an audience that Jesus told him, Jesus wants revenge. How does that play? And revenge in the form of somebody being burnt up in the most painful way. You know, Mr. Kearney expresses concern that I gather what Lieutenant Tully is supposed to have done to his children is arrest Mr. Kearney on one occasion pursuant to a warrant at the bus stop after Mr. Kearney brought the children off. If Mr. Bradel had looked at the discovery that the Commonwealth turned over of the body cameras of the arrest, he would observe the officers carefully waited for the children to get on the bus and be on their way before their father was arrested. But yet, this is continually held out as a crime, while at the same time, Mr. Kearney has no compunction about wishing death on Lieutenant Tully's children. So, Your Honor, I make those two arguments. One, this was posted with a sure and certain knowledge and intent that it comes to Lieutenant Tully's attention, which in fact has happened. And two, I make the point that a no contact order means no contact. The content, you know, before Your Honor, here's the First Amendment argument. The content of the contact is irrelevant as far as whether there was a violation of the order. And I'd just like to call Your Honor's attention, if I can do it, to a case that I cited in my memorandum to Your Honor. I believe I cited it for another purpose, but it's O'Brien versus Borowski, 461 Mass 14. In the course of that case, the court refers to the Cho case on page 424 of the opinion, and it summarizes that case as follows. The defendant produced flyers with the word missing printed in large type across the top, between which was a photograph of a former girlfriend who had broken up with him, and offensive sexual remarks about her. He then hung the flyers in several places in her high school. He was convicted under a statute which criminally punishes persons with offensive and disorderly acts of language that cost or annoy persons of the opposite sex. We, that's the appeals court, concluded that the defendant's criminal conviction for this communication did not violate the First Amendment because it was a true threat that had no expressive purpose, but was instead intended to get back at the victim by placing her in fear that she might suffer some sexual harm or wind up going missing. Your Honor can look a long time, I think, at the language of Mr. Kearney's message in an attempt to distinguish it from the Cho case in terms of the language having no expressive purpose, but instead being intended to get back at Lieutenant Tully by placing him in fear that he or his family might suffer some harm. In fact, what other meaning are we to draw from revenge? Revenge. But apart from that, Your Honor, even if there's some far-fetched First Amendment phrase somewhere lurking in this message, the other material is not protected, and the violation of the order does not consist of the language, but simply the content. Now, the other string in my bow, Your Honor, is the argument that this is again a violation of the intimidation of the witness statute. Mr. Kearney and I have gone back and forth on that statute and how it should be construed and how it should not be construed, and how he currently has it under advisement. You see my arguments in my memorandum here with respect.
Good words, construed. You're construing his words because Kate Peter told you.
I won't belabor them in oral argument. So I will rest at that point.
Okay. Mr. Bradel, tell me about that word revenge and how am I supposed to interpret that?
Judge, this is not a threat. This is not contact. This is satire. This is all protected. I am so sick of having come before a court because of Norfolk County and talk about speech that Norfolk County doesn't like.
Not to anybody else. Just tell me about that word revenge.
Revenge. Excuse me 1 second.
Yep, no, take your time. You can confer with your client.
Judge, my client is allowed to have hopes and desires and wishes that you or me or Mr. Cosgrove don't agree with their own life or are repelled by. You know, why do we keep having to come back here? I don't know what it must be like to wake up on the wrong side of the First Amendment every day. This is protected speech, Your Honor, over and over again. The Supreme Court has spoken for decades and decades. Brandenburg, Watts, Chaplinsky, O'Brien v. Borowski, Welch. Judge, this is a waste of this court's time. This is intentional infliction of emotional distress on my client. The Commonwealth has been rebuffed over and over and over on this exact scenario. He is not contacting a witness. He is not threatening a witness. He is talking about someone who has destroyed his life, Your Honor. He is allowed to lash out back. And the First Amendment grants every declarant this room to talk without fear, without the kind of fear that this county has inflicted on Mr. Carney over and over and over again. And it has to stop, Your Honor. This is First Amendment protected speech. I don't care if we don't like it. I don't care. It doesn't matter. He is not threatening Tully. He is not contacting Tully. He is a reporter with his own style of satire that is addressing a large audience, and he is doing a major service pointing out over and over and over again corruption in this county, perversion of the First Amendment, abuse of the witness intimidation statute, Your Honor. This has got to stop. I don't want to come in here anymore and pretend like, gee whiz, this is a close call. It's not, Your Honor. This is First Amendment protected activity that the court, I have every confidence that this court is going to vindicate. This cannot happen over and over again. I get a motion to destroy my client's liberty 3 hours before every single time they want to do this. I get communications, oh, we're not going to try to revoke his bail. Then I go to Stoughton, they want to revoke his bail. What are they doing? They're corroborating the affidavit we talked about 5 minutes ago, where Jennifer McCabe said, I'm not going to test.
I'm interested in that. I'm interested about the word revenge.
Judge, he can say revenge. He hopes it's revenge on a bad guy that's been destroying him. We cannot engage in this kind of content-based viewpoint discrimination. We don't have to like the viewpoint, but like Voltaire's biographer said, we have to defend to the death his right to say it. And that's all this is, Your Honor, over and over again with this. Excuse me 1 second, please, Your Honor.
Yep, take your time.
I think he does rattle off here a couple of statutes that support his position, but the one I would be focusing on is the Brandenburg versus Ohio test, because that gives you 2 prongs. The first prong is intent to incite imminent lawless action. So he's got to have the intention. And 2, that such lawless action is likely to occur as a result. So satire, criticism, even scathing, uncomfortable, vulgar satire is still protected speech unless those 2 prongs are met. So that's the test, the Brandenburg versus Ohio test. I think he does mention it at some stage here, though.
And Judge, in this context, to address your question, in this context, Judge, revenge means karma. He's not saying, I'm going to go get revenge on you. He's saying that karma's a bitch, is what he's saying, Your Honor. And he's allowed to say that. And this isn't something that is intended to be played on a judge's bench in the formality of the courtroom. This is something that he is talking to his viewers online. And he's allowed to do that, Your Honor. So we have got to stop the charade that this is somehow, gee whiz, we got to lock him up because he's talking and satirizing, engaging in political hyperbole, protected by Watts, Brandenburg. The only thing he can't say are true threats and fighting words. We all know that 100 times over. Why are we here, Your Honor? I ask that you deny the motion and just please issue a ruling that settles this issue once and for all, that this has a chilling effect, Your Honor. Every time
Somebody give the man a binder to smack on the podium.
we're here, how many journalists do you have in this room?
Okay, I'm up here. Director remarks to me, not to anybody else.
No, I'm just looking to see if there's journalists.
I'm up here.
There's journalists cover this case. They are experiencing a chilling effect. Am I next? Is the Commonwealth going to go after me next? How far can I go? Can I show up at someone's door and knock on the door? Oh, did I intimidate somebody? Is Norfolk County going to go after me? We don't know. We don't know what they're capable of. And, Your Honor, you're the bulwark here. This is the First Amendment we're talking about. We're kicking this around like it's some city ordinance.
Okay.
Thank you, Your Honor.
All right, I'm going to take it under advisement. Mr. Kenny, please stand up. You're walking on kind of thin ice. I'm going to review everything and I'll come out with an order. But I take what Mr. Cosgrove has presented very seriously. I also take into account that there are certain First Amendment rights here as well. And then the issue is always how far does the First Amendment take you and when does it become intimidation of a witness? The word revenge, some of those other words that are on that tape are getting very, very close. So I'll take it all under advisement. Let me just see the lawyers inside back.
It's getting very, very close. No, it's not. It's satire, you moron. He's going to do an order. So I love it. I love it too. Bradle's going off. Yeah. And it's it matches my level too of venting. So I love it. So I didn't actually see the video that they're talking about, or did I see it and I just seen it as satire? Like I literally didn't take any notice because I have watched most of his stuff. Let me see. Let me see. Might as well do it in this window. Does anybody know which video he said that about Tully in? Here comes the rain. So the only one I haven't watched is this one, which is about Jan McCabe. So 5th of March. April, May. That was ages ago. God damn it. I probably did miss it. Thanks, Kerry. Kerry's on the hunt for me. Yes, this judge is awful. He literally stopped giving us this bullshit, split the baby close-up call shit. There's a link in the briefing. Oh, there was a link in that video we're just looking at. Is that what you're saying? Hang on. Wait.
Well, and then the issue is all.
Defense Fund, Turtle Club, wax the show, read the blogs, grab some turtle merch, top 50 stories. No, unless I'm not seeing it, there's no link there. Right, so Kevy's on the hunt. We'll see how we go. The night before his court. But yeah, it was in March. This court hearing here was just a couple of days ago. But it was before this. It was a month before this. I think it was March 5th is what they stated. Cosgrove stated. All right. So Carney's videos are, by all public observation, full of mockery, sarcasm, exaggerated characters, satirical storytelling. Unless he directly called for violence, what Cosgrove's doing here fails the Brandenburg versus Ohio two-prong test. 1,000 angry DMs to Tully doesn't prove either of the prongs in that test. Arresting him in front of the school bus, that alone says more about prosecutorial theatre than public safety. It wasn't about justice. It was about optics, humiliation, and a chilling effect. Arresting a father in front of his kids and the schoolmates with zero tactical need to do so, that's messaging, not law enforcement. The audience's behavior is not the creator's responsibility. So that's getting real, right? If an audience member sends a nasty message to a public figure after watching content that criticizes that figure, that's not on the content creator, unless they directed it explicitly. Otherwise, every late night host, YouTuber, or journalist could be blamed for their comment sections. Exactly. And the person who actually proved that to be true in several different states now is BJ. If you guys watch her channel, That Surprise Witness is BJ. March it was, Kevin, I think. March 5th, apparently. A video in March. Hang on. I might have to go back and have another look. Hang on a second. So BJ has actually overcome these two prongs in multiple court cases now, where I don't know if you've been following her cases, but particular people have been trying to sue her for all sorts of things and get restraining orders against her to stop her talking about them on her channel and blah, blah, blah. So she's actually, I think it's in 3 different states, overcome that. What's it called again? Ohio. Hang on. What's the name of the test again? Brandenburg versus Ohio test for incitement. So just by proving that she tells people too many videos and hours of video. Okay. I'll find it for another show, Kevy, eventually. It'll be posted on X at some stage, I imagine, and that'll help us work out where it is. The Glera played the reel. Cynthia says the Glera played it last Wednesday. The hearing was last Wednesday, and Glera played the reel. Okay. So yeah, essentially that that particular case, it's a federal case. Brandenburg versus Ohio. I think it's a federal case. To overcome incitement, they have to prove intent and that they told the audience to do this, and that lawless action was likely to result. And as I was saying, BJ's overcome that 3 times now, 3 different court cases. So, right, I'm the same, Lonsolo. I'm the same. So, free speech doesn't mean free of consequences, right? So, if you get into trouble because you did it, then you're not free of consequences. But to criminally charge you for what you said is a whole other ballgame. And that's a legal consequence that I don't think is applicable. So, okay, no worries. Checking the Glera. We got Kevin on the hunt again, still. If he finds it before I end this, which is not too far away. All right, so Bradle did a sidebar. Brownie got Carney got a warning. What did we end up at?
Judge, how far out were you contemplating?
Maybe about 5 weeks.
Plea date, 5 weeks.
Could I suggest June 8th?
Is the 20th available?
No, wait, what's the cutoff?
I'm looking for June 20th, that's a Friday.
Yeah, that's the
June 20th.
Yes, I think Mr. Brady and I are supposed to be trying a district court case relative to Mr. Kearney on the 9th of June, but it should be included by.
Yeah, I would think so.
Yeah. So that's fine. 2 o'clock or?
Okay, the 20th. Thank you. I'll see you all then.
Thank you, Your Honor.
May I try your patience?
Try my patience. Who else?
So he has a plea hearing on the 20th of June. Episode 5, here we go. Teacups on it. Episode 757, and it's around the 37-minute mark, heavy. It's just like Bev attacking the defense while admitting they did nothing wrong. Yeah, exactly. It's the same thing. Exactly. Did you get that, Kev? He's muted me to go and listen to Glera's stream, so that is why there are defamation laws. Right. Just if that's what's going on, take it up with defamation. Like, if this is a civil complaint, this is not a criminal complaint. So they are mad that Carney's coverage embarrassed them on all of those cases. The drug lab scandal, the overtime scandal, and now the Karen Read scandal. They hate the memes, they hate the nicknames, they hate the receipts, the fact that his videos unraveled the narrative in all of those cases. So now they're probably playing the he caused the mob card retroactively to criminalize the speech. But unless he said, go threaten Tully, or something straight out like that, then it fails the 2 prongs of that case law, so of that test. So release the Kraken. So I really do want to hear what he said that caused this, because I know that Kate Peter listens to everything that he says, and then she takes it out of context. She uses it like she twists it into something that it's not. She writes it in her little email using, electronic medium. That's a RICO offense, to send these little stories over to Cosgrove, and then Cosgrove just believes it, and he takes that little snippet of whatever it was that he said, because, who has time to listen to a 3-hour Turtle Boy stream except for Kevin, because he's looking for shit for me. But yeah, that's how that all goes down. That's what that judge said, right? F-bomb. The judge said that. Episode 757, 37-minute mark on TV's channel. I think he's listening. They even hate the ducks. Indeed they do, Carol. The length that Jen went to make sure not to put shock and horror into the same sentence is clear evidence that Jen is watching. Always watching. Even when AJ tried to get her to. That's right. Indeed. All right, so we still don't have it. I might even be able to find it quicker than Kevy. Let's have a look. 757, you say. 757, 37-minute mark. Somewhere here.
Because I would.
Let's go.
And yeah, it's like, that doesn't mean that I am threatening Brian Tully or I think anyone should hurt him. I don't. I'm just saying, like for instance, like that Brian Tully.
Let's go back a bit.
And so he got CC'd on this email the other day complaining about me. You guys want to read it? You got to see this email. You got to see this shit. Okay. So he claims that. All right. So this is the email. All right. All right. So this is from turtleboyexposed@gmail.com. Mr. Tully, I am writing because Aiden Carney did a live video on YouTube on 4/26/25 that I felt you should be aware of what he stated. These people are such little snitches. Like, they're such little bitches, huh? Little hall monitor motherfuckers. Like, this is all they do. This is your life, sitting there being like, Brian Tully, did you hear what Turtle Boy said about you? Yeah, I said that that if Brian Tully died in a fire, I would get erect from that. Because I would. And
26th of April.
That doesn't mean that I am threatening Brian Tully or I think anyone should hurt him. I don't. I'm just saying, like for instance, Brian Riccio died last year from something. I don't know what it was. And I'm like, that's fucking awesome. Like, the day that Brian Riccio died was such a great day because Brian Riccio was just such a worthless, evil, despicable maggot that the second that he stopped breathing the same air as me was like a gift from fucking God. Like, I'm so glad he's dead. And so is everyone else. I'm so like every day I wake up and Brian Riccio's dead. I'm like, oh, it's a good day. Riccio's dead. Oh, fucking awesome. That's why you didn't even have an obituary. Nobody went to his funeral. Nothing. He's dead, and it's fucking awesome that he's dead. So, like, Tully's the same thing. It's like if Tully died tomorrow, I'm like, that's fucking great news. That's great. That's fucking great. That's not saying that I want to kill Brian Tully or I'm going to hurt Brian Tully. I'm not going to do any of that shit. I'm just saying if he died a painful, slow death tomorrow, I would be like, okay, good start to the day. That's all I'm saying. That's all I'm saying. This is not a threat. It's just saying, and guess what? All these motherfuckers out here crying about this shit would fucking love it if I died. They would love it. Not a single one of them would be like, that's so sad. He leaves behind 2 children and, a big family and all these. None of them would think that. They'd all be like, yes, Turtle Boy's dead. They would be so fucking happy about it. So, like, all these crying ass bitches out here would do the same fucking thing. If Karen Read died, if I died, they would fucking love it. So get out. Nobody's buying your faux outrage. But anyway, these are sick people, though. So they don't really think straight. So he goes, I've tried to figure out how to report this, but I cannot figure out which law enforcement agency to contact as I am out of state. So this is like somebody who's not even from around here. Below is the video link and transcripts. I share because Aiden blows the silent dog whistles. His followers tend to take action. So whenever you see the term dog whistle, historically what that means is that I don't have any proof. This guy didn't actually say anything, but he said something, and this is how I interpret it meaning, and he didn't actually say to threaten people that he wants to threaten somebody, but other people will secretly take that and be like, ooh, he's telling us to threaten, which is just fucking baseless. You can say that about anything as a dog whistle. Like, so whenever anybody who uses the term dog whistle is just devoid of facts or evidence. That's what, whenever you say the word dog whistle, it's because you don't have evidence on your side. Okay. So this person claims I'm sending out dog whistles about, and as how much time they spent on this, God knows, because they have transcripts. If you go to that link at approximately 40:51, he is wishing that your home catches fire and that you, your wife, and children die in the home. That's untrue. I never said that I want his children to die in the home. I think I said it would make me happy if they didn't have a father, I would be happy.
Hang on. Can we get the link this way? He's got it zoomed up. Oh my God. LVP3N. Let's see if I can do it this way. Let's start with youtube.com. This is the hard way to do it, right? youtube.com/live.
Do you want me to call it out?
/
Do you want me to call it out for you?
Yes, /live. Go from there.
LVP.
Hang on, watch. Question equals, right? Hang on.
Yeah. I have a bigger screen here, so I could probably get it quicker for you if you want.
Hang on. It's not watch. Okay. LVP. Go on.
LVP 3. N for Nora.
N for
Small
Nora.
G.
G.
RVO. YK. Question mark SI.
Question mark SI.
Equals ILB.
Yep.
3S. I think it's FD.
3SFD.
IMT.
Hang on. I need to just quickly look at the screen for 1 sec. Oh, these are all capitals. You weren't telling me capitals.
Do you want? Okay, sorry about that.
IL little B3. Okay.
Big S, small F.
L little B3. BS small F.
D, small A.
Which D? Big D or little D? Big
Small
D,
I,
small
big
I. Big M.
For Mary, that is. T, small T.
Small T.
30.
30.
Big H.
Big
small
H.
X, small N, and small M. So that's N for Nora and M for mother.
X, N, M.
Yeah, all small X and M.
All right, let's see if we got it. That video isn't available anymore. I took it down.
Probably took it down because of that case or that hearing.
Because it's part of a court case now. Damn it. We went into a lot of trouble there.
And how much time they spent on this, God knows, because they have transcripts. If you go to that link at approximately 40:51, he is wishing that your home catches fire and that you, your wife, and children die in the home. That's untrue. I never said that I want his children to die in the home. I think I said it would make me happy if they didn't have a father, I would be happy. That's what I said. I don't want the kids to die because the kids are innocent and they should be left alone. But I don't care if he dies. That's what I'm saying. And so, because my kids didn't get to see me for 60 days because of him. And that was painful. And that is something I will never, ever, ever forget. Fucking ever. I will never forget. And he tried to do it again. I will never. Do you think he gave a fuck about my kids when he did that? Do you think he sat there and thought about them for 1 fucking second? No. So I don't give a fuck about him, and I certainly don't give a fuck about his kids. Okay? Shut the fuck up. Back to this. So he goes on to say, he does state it isn't a threat, but he goes on to discuss another individual he doesn't like, that he doesn't wish they would die, but he wants you to die. What? I take that as a threat, but I'm not a police officer nor attorney. Just an individual in the Midwest. Oh, is this Julie Carpenter? Concerned about people surrounding this case. I will be forwarding this email to the Norfolk DA's office for Attorney Cosgrove, as you are a witness in the Karen Read case, and Aiden Carney is witness intimidation charges pending. I also have attached transcripts to that video. It would help if a law enforcement officer or attorney reached out to YouTube regarding the video and reported it. I will be reporting it myself, but usually don't get much response, nor do they remove threats like these without a level of law enforcement emailing or contacting them. I am providing the legal department email for your YouTube, Google, if you feel this warrants a complaint. The best part is they sent it to a guy named Brian Tully, who is a turtle rider. You sent it to the wrong Brian Tully, dipshit. I mean, this fucking, you can probably find real Brian Tully's email address like publicly listed. Oh, just, it's too great. Okay, back to these donos here. Thank you, Nikki. Elizabeth sends $20 and
That's
goes,
funny.
Hey.
Bloody hilarious. So, yeah, it's a bugger he took it down, right? Hang on, give me the rest of this. No, he's got no chapters set up on it. No, he does have chapters. Dono reads, stream boat, weapon. All right, there you go. He's no longer up. I'm having an audio issue. All right, no worries. Well, Kevy, we can wrap it up anyway. You don't need to come back. I think we're pretty much done. Oh, he's back. I wasn't even looking at that screen. He's back. I think we're done now anyway, Kev. So sorry about your audio issues. Let's stop sharing those screens and put us back up here. There we go. Yeah, interesting. So he said he thinks it's Jen's sister. You think that's who it is, Jen's sister? Like, they just make up bullshit. Like, I saw them posting, oh, Turtle Boy's doing this and Turtle Boy's doing that, and like pretending that they are Turtle Boy doing shit and then going, look what he done. Like, they're just so fucking foul. They're just playing dirty all the time. So, yeah, I come to expect it from these people. So it's the lies they tell that are doing the biggest damage. Exactly, Kev. Feel free to unmute. We're going to say our hoorays now. We've been up for 4 hours.
4 hours.
Kev. Is it 4
That's great.
a.m.?
Double time. It's a bank holiday here, so I'm on holiday pay.
Cool. But it must be getting close to 4 a.m. for you, right?
It is 3:32.
There you go. Marathon effort by Kevy the Supermod.
Hello, Michelle just posted something here. Aidan actually did say that we hope Tully's whole family died in the house fire. I think he admitted that. I think he admitted that. And he justified it. I did hear that, actually. Now that I read that. He followed it up by going on about how he was arrested in front of his kids and sent to prison for 6 months and nobody gave a damn about him. So why should he give a damn about Tully and his kids and blah, blah. Yeah.
Blah, blah. I don't know if you noticed, but she did put a shh beside it and you didn't shh.
No, there's no shh beside what?
I think it's pretty much known. I'm the only one who didn't know by the sounds of things. Busy doing my own channel and miss a lot that's going on unless someone tells me, which is generally one of you guys.
I'm
right?
reading the message she sent me in Discord here. Did she say something in chat?
No, the one in Discord, she's got the little shush face. Or maybe.
Oh, okay. Sorry. Yeah. Okay. Forget I said that.
For fuck's sake, Terry.
No, but I did see it. I did see it, and I did hear it. So yeah, 100%. That's what he said.
And I'm generally in the dark unless you or
And to
Michelle
be fair,
Bloody
that's not
fill me
insane.
in.
That's not insane. As distasteful as some might find that, it's not
He's
incitement.
allowed to say it.
It's not incitement to anything.
incitement.
Yeah, it's not fighting words. It's not a threat.
No. It's not telling the audience to go burn his house down.
Correct.
So the two prongs being under Brandenburg versus Ohio, intention to incite imminent lawless action, and such action is likely to occur as a result. Those are the two prongs, and they're going to fail it on both.
Oh, I'm going to get it from Michelle now.
Oh, yeah, she's going off. You're going to get smacked.
Thank God there's
hard.
Thank God there's 10,000 miles separating us.
Smack him hard, Michelle. He deserves a smack on the butt.
Oh, please. Yes, please.
Yeah. All right, Dee Dee Delgado. That is Jen's sister. Is that who Turtle Boy Exposed is? They just type the most stupidest, revoltingest stuff. Like, they were harassing me for ages. Let me show you.
Oh, they can be very revolting, and
yeah, they were harassing me for ages, and I just kept complaining to YouTube until they stopped complaining. So sorry, Corn Pope. Aidan Carney warning about emotional distress. Aidan Carney, I think Henry has got out of church service. Is he talking about? Who's he talking about? I don't know who they're talking about, but anyway, fighting words that are intended to induce emotional response in the average person and have no basis in fact. Yeah, that's the Massachusetts law, but don't forget there's federal law that overrules that, and there's two protests. So,
yeah.
Wouldn't the phone calls Aidan Carney made to witnesses in the Karen Read case be wiretapping as he did those calls on live video that was recorded? Did he inform Jill Daniels and Jen McCabe, whoever else he called, that he was recording them on a YouTube channel? I don't know. Are you even watching his videos? I'm pretty sure he did. If you were watching them, then you'd know, wouldn't you? You'll know this is just a distraction for what's going on behind the scenes. They are paying for crowds on demand. Oh my God, Kevy. Crowds on demand.
Well, I'm still waiting for my check.
Is that even a real thing?
It is actually a real thing. Yeah, you can hire crowds to turn up to events for yourself. And
hang on,
you can buy anything now, Ozzy.
Crowds on demand, really? Crowds on demand. I'm googling it because I don't believe you. It's actually called Crowds on Demand.
Yep. You can get them to turn up to your birthday if you're Philly nomads.
Protests, rallies, advocacy, the fucking roo-roo. There you go. It's an American publicity firm that provides clients with hired actors to pose as fans, paparazzi, security guards, unpaid protesters, and professional paid protesters. The company operates in Los Angeles, San Francisco, Las Vegas, New York City, Washington, D.C., Iowa, and New Hampshire. Well, there you fucking go. It's real shit. I didn't know that.
Only in America, huh?
You are dead to me mantra. You know what? People say that all the time. It means I'm not your friend anymore, moron. When Karen Read goes to prison, I'm afraid that she will be glorified. Oh, you can just be afraid for glorification. You just be afraid, bitchy one. Self-defense strategy, interrogation and intimidation. What? That's what the cops do, moron. AJ is trying to keep witnesses on the stand for days to get them to break.
Pregnant pause.
Pregnant pause. AJ's doing the cops read technique. Oh my God, this person's a fucking clown. Oh, look at that. See, they know they're a clown.
I'll tell you, I've been on X the last, I don't know, since day one of the trial, looking for the trolls and going to war with them, and they have been extremely quiet since Friday, since Jen left the stand.
Jen McCabe is doing beautifully.
Yeah.
She's still, look, could my email go to Cosgrove, Tully, and Hank and help get Turtle Boy's bail revoked? We can only hope. There's consciousness of guilt right there. We're trying to get him locked up. I'll just leave that on the screen. We don't need to go too much into these because they're just all hate bait, basically.
They're getting absolutely trounced. And what I see in a lot of the comments now in response to a lot of them is they're just dropping in to see their comment or their post getting ratioed, and they're getting crucified. The numbers are overwhelming in favor of Karen Read, just hugely overwhelming.
Wait, it's gone though. Turtle Boy 756. Hang on.
What's this for? You want a link for something, do you?
No, someone's in the chat still giving us directions, but I'm pretty sure it's gone. 756.
40 minutes and 58.
40, 58. Turn it up. Share screen. Looks like we're doing it again. Share screen, not that button.
Karen Read poll.
She's just insane and sick. And so when I broke the Karen Read story a couple years ago, I'm like, okay, cool. She's gone. I can focus on this. I'll never hear from her again, whatever. Nope. She had to involve herself. So she took the contrary view that I did, that Karen Read is guilty, which she doesn't even believe according to this affidavit that was filed. And because she wanted to be like the antithesis to me. Well, now she's famous. So good job for all the wrong reasons. Okay, thank you. Tiny Elvis sends $10, goes, the defense needs to hammer Tully on the stand this trial. He is literally involved in every aspect of the case. I agree. Tully is the mastermind of all this shit. Fuck that corrupt piece of shit. It pisses me off that he gets away with this shit. Fuck him. He was rehomed, but he's still involved in my case and tried to have me locked up again last month. He can go get fucked. Him and his stupid wife and his stupid family. I hope they all fucking die in a fire. Fuck them. Next up. Not that that's not a threat. It's just what I hope for. You know what I mean? If I found out tomorrow that Brian Tully.
Wait. He just said, that's not a threat. Don't do it. So this is the opposite of what Cosgrove is saying that he done, right? This is how BJ won hers, because anytime she said something negative about the people that were suing her, she added at the end, that's just my opinion. I'm not telling you all to go out and harass a person. In fact, don't go out and harass a person. So let me just replay it. He said, don't. Whoops.
Intimidation against me. She's just insane and sick. And so when I broke the Karen Read story a couple years ago, I'm like, okay, cool. She's gone. I can focus on this. I'll never hear from her again, whatever. Nope. She had to involve herself. So she took the contrary view that I did, that Karen Read is guilty.
He's talking about Kate.
Which she doesn't even believe according to this affidavit that was filed. And because she wanted to be like the antithesis to me. Well, now she's famous. So good job for all the wrong reasons. Okay, thank you. Tiny Elvis sends $10, goes, the defense needs to hammer Tully on the stand this trial. He is literally involved in every aspect of the case. I agree. Tully is the mastermind of all this shit. Fuck that corrupt piece of shit. It pisses me off that he gets away with this shit. Fuck him. He was rehomed, but he's still involved in my case and tried to have me locked up again last month. He can go get fucked. Him and his stupid wife and his stupid family. I hope they all fucking die in a fire. Fuck them. Next up. Not that that's not a threat. It's just what I hope for. You know what I mean? I would, if I found out tomorrow that Brian Tully was burned alive in the most painful way possible, I would be so happy. Like, I would be awesome. That'd be great. I hope he dies. Like, I hope pain and misery happens to him after what he's done to me, what he's done to Karen Read, what he's done to my children. Like, I really fucking hope, like, I would get so fucking hard if you told me Brian Tully died in a car accident tomorrow. When I heard Nicholas Garino got hit by a car, I'm like, you know what? That's fair. I don't want him to die because he's not like the main villain, but he's bad. Like him getting hit by a car was actually good. Like that was actually a good thing that Nicholas Garino was hit by a car. That's called karma. He was hit by a karma because he deserved that for what he did to Sandra Birchmore, what he's done to Karen Read, what he's done to me. Fuck it. But Brian Tully actually deserves to get hit by a car and die. That's the difference between them. Like die. And so I don't give a fuck if he dies. I don't give a fuck who he leaves behind. I hope it's painful. I hope every single waking moment for the rest of his life is miserable because that's what Jesus would want me to do. Okay. I don't, this fairy tale about, I go to church every Sunday and that's what Jesus talks to me. And that's what he says. Revenge. So anyway, that's that. All right. Back to this.
Interesting. It fails both prongs of the test though. I keep forgetting the name of the freaking test. Brandenburg versus Ohio test. There's no intent to incite imminent lawless action. He's just hoping something bad happens to Tully, and he hopes it's as bad as possible, but hopes that's not inciting. And he said it's not a threat. He just hopes it. So such lawless action is likely to occur as a result. Fails on that as well. So that's the difference exactly. It's exactly it. So interesting, right? Kevin's got a little rhyme. Raindrops on roses and whiskers on kittens, bright copper kettles and warm woolen mittens, brown paper packages tied up with strings. These are a few of my favorite things. That's actually an ad here, and I fucking hate it because it's an ad. Because you hear it like 5 million times a day. It's not a threat, right, Son? Exactly. Not a threat. He's just saying he hopes, and the way he said revenge then is more like karma, not that he's going to go out and do something or anyone else is going to go out and do something. So, no, he doesn't have to stop AJ. In fact, he's free to do whatever the fuck he wants because America's still a free country, right? He doesn't have to stop. So, on the Bev shook her head thing, Brennan shook his head thing. There's nothing that they can make of it. All right. He can deny that he was doing it towards Bev, and Bev can deny she even saw it. So, you know, how can anything be done about that when they can just deny it? So, oh, it's out of The Sound of Music. There you go. Never watched it. I try to avoid old movies like that. They're actually great. I mean, I like some musicals, but I don't like musicals in general. So, like, for example, I enjoyed Johnny Depp's Sweeney Todd. That one of the only musicals I ever did enjoy. I think he must say that bit about her KP changing sides and that KP doesn't really believe Karen's guilty a lot, because I remember him saying that a long time ago. Well, it's because it's true. And even people that she's talking to on her side, she's saying it to as well. So, no, he keeps getting into trouble. So when the cops are coming down on you and the state is coming after you, that's your fault. Is that what you're saying? Because that's not how I see it at all. That's not how I see it. That's the cops getting into trouble. That's the cops doing the wrong thing. Just because he's the focus of it. As you may have missed the beginning of the stream, he's the one who made it very loud and clear about the drug lab scandal way back before Karen Read ever came up, even before John O'Keefe had died. He's the one who made the big song and dance about the overtime scandal, and now he's making a big song and dance about this scandal. That's why they're going after him. It's not because he keeps saying stuff. It's because he's reporting their abuses of power. So I think you got it backwards. So if you're the type of person who's going to back down, don't become a journalist. If you're going to say, oh, I'm scared because everything I say is getting me into trouble, don't become a journalist. So he's brave. He's a good journalist. He brings attention to the right things. And that's why they're going after him. And they want to know who is leaking from the inside, right? Exactly. Shelley babes. Oi, oi, oi. Good to see you, babe. Good to see you. Thank you, Nightbot. The appropriate response. So, is there any validity to the affidavit filed? Give me some hope here. There is some validity to it, yes. So, if you want to talk about, what parts of it are valid, we already know that Fanning was involved with Juror A getting dismissed and some other things there. We know some of that stuff's already come out. So that part's kind of verified. We already know, I actually forget what was in the affidavit just off the top of my head, but I can think of, when I was reading it, I could think of at least 5 things that Betterow has already substantiated through emails from Morrissey, access to Kate Peters' phone, access to Lindsay Gattani's phone. So at least half of what she said was verified. So yeah, there is some validity. So we can have some hope. He's getting intimidated for exercising his First Amendment rights. Yes, it doesn't really matter if he's a journalist or if he's just a YouTuber or if he's just a blogger. He's still got those rights, right? So he's going to open a separate case. I'm not sure what you're talking about. I do know that he's got a plea hearing in June, though. Hi, Brett, by the way. And AJ, sorry, by the way, hi. But they are dealing with very corrupt cops. Right, if you're afraid of corrupt cops, don't go after them. But he's not afraid of them. I get that you are and that you think he should be afraid of them, but he's not. And he still has First Amendment right to point at those corrupt cops and call out their corruption. So there's a First Amendment auditor cop watching from Colorado. He wished death on a judge. He pled guilty. The prosecution was making a deal and the judge completely threw the deal away. The prosecutor was in tears. Eric Brandt was sentenced to 12 years. Interesting. Michelle says, yes, that's what the judge is doing, making a separate case. There you go. Confirmed. Gotcha. But he can do the ad hominem attacks too, Fern, because he has a First Amendment right to do them. So I have to believe there was some validity to it, or Betterow wouldn't want his name attached to it. Exactly. I had to believe that too, but if you had gone through all of the Betterow letters and understand what it is that Betterow turned up in those and was talking about in those letters, you can see there's correlations that match that affidavit all over the place. Everything in America is corrupt these days, right? Well, Turtle Boy focuses on his local area. He doesn't do everything. He just does his local area. So the drug lab scandal was his local area. The overtime scandal, his local area. Karen Read, his local area. So he just narrows it down to stuff that affects him and his local area, basically. Demp Dog, I'm not afraid. Let's go, Aussie. Let's go, TB. I'm not afraid either because I'm not in America, but if I was living where TB's living, I don't think I'd be as brave as him. Like, it would have only taken one charge and I would have shut down. So there's that. I'm not as brave as him. there's a lot of people that are not as brave as he is. So any judge worth his title would throw exactly. I agree. But we are in the twilight zone, right, Gab? We indeed are in the twilight zone. Yeah, so there you go, guys. That's what he actually said versus what Cosgrove's saying he said. And I did actually watch this stream. And I did hear it, and I didn't take any notice of it because it didn't seem to be that big a deal to me. Like, it didn't come across as a threat to me. Having listened to it several times over now, he's actually qualified that it's not a threat. So Cosgrove's reaching here. I was gone for 4 days. Yeah, my grandma had a stroke, so I had to go deal with some stuff. And my car's got to be registered, and I got shit going on. So I was out of action for a bit. All right, guys, I think we're done here. We need to let Kevy go to bed. Poor Kevy. It's nearly 4 o'clock for him, so in the morning. It is now it's just after lunch here. Replug the questionnaire. Yes. I think I got it pinned, haven't I? Yes. So the scorecard at the top, pinned in the chat here. If you follow that link when we're done, you can fill out the form that is attached to. Oh shit. I closed what it's attached to. Hey, wait, we can't go yet. We got to do a game. Hang on. Wait. Let's do a game. Who wants to play a game? I got to remember we're closing out every live stream with a game now. So wait. Don't go anywhere. Share this tab.
We definitely need a few for Proctor.
We need some for Proctor. Yeah, I've always said Proctor. Everything got proctored. Uh-oh, that got proctored. All right, let's do game. Game time. All right. Active chatters, we'll start there. Start with that game. Anyone who is active in the chat in the last, excluding moderators, because they've already got access to the bot anyway, in the last 10 minutes gets to play the game. Also, what you win is access to the bot. Your own personal bot command is what you win. So everyone who has typed something in the last 10 minutes gets to access the bot and have their own command. And we don't have a limit on how many commands you can have to the bot. So you can win it multiple times if you want. You've got to be active. For this part of the game, activity within the last 10 minutes. So if you want to be in it, go. Be active in the chat. Let's go, folks. A minute later, they'll hear me say that. Any minute now. Any minute now. Here we go. They must have heard me. Let's go. Type something in the chat. You can be active to be in it, to win it. You get a free bot command. It will respond to your command. Ooh, a nerd game. Nerdies indeed. Popcorn, Higgy. Yes, it's counting bot commands as interaction in the chat. So cool. Plow. Higgy, popcorn, plow. Okay, going off. Quality Emerald. She wants to be in it. KT, FBI. Jess Dawson, you're in. Tracy Summers, you're in. Shelly Babes, you're in. Carol, you only get one chance. You can type as many as you like, but you're still only in it once. I just lost my lighter. Where the fuck did I put my lighter? All right, guys. Do it. All right. We're doing it, Nightbot. The winner is KT.
Well done, KT.
Let me get KT's deets out of here. KT, you are that one. You get to choose what you want the bot to say. So we go into command. No, first we go into regulars. We add KT as a regular bot operator. Then we go to commands and we ask KT, what's your command, KT? You typed a couple of them, but tell us what your command is. Carol M's still going off. Guitar pick.
Guitar pick.
I want to be in. Oh, okay. Wait for it. I see. We got 2 more games yet, so you can be in.
Have I allowed somewhere? I thought we had.
Yeah, waiting on you, KT. What command? So you type exclamation mark, your own command, and then what you would like the bot to reply. So while we're waiting for KT to give us her bot command, Kevin, you can
Sorry, go on.
You can catch that for me in case I miss it. If KT gives her command, I'll play another game while we're waiting for KT to think of one. Is there one for Jen? There's actually 2 for Jen already, KT.
Yeah, we have
and
Jen, How's Long Till Kerry Shuts Up, and JM is Jen.
And we're not doing tooth jokes because I've got tooth problems, so no tooth jokes, all right? No tooth stuff for the bot. Otherwise, you're having a go at me. I got the same tooth problem, exactly the same tooth that's sticking in the wrong place.
But yours wasn't smacked. Yours wasn't smacked out by Brian Albert. Is that defamation? I wonder.
There's a point. What's going to be our keyword, Kevy? You get to choose the keyword. What keyword are we going to play with?
This is the one where we use the prompts, is it?
This is where we use the prompt. The phrase that users must type to enter the giveaway.
We
only get 1 entry, so you only type it once to get in.
Nefarious. No?
Nefarious. That sounds great. Right. So everybody, I'm going to make it more difficult because it's a bot command. You need to have the exclamation mark in front. So you're looking at the screen. That's what you need to type with the exclamation mark. Ready, set, go. All right. There'll be a minute catching up for the go bit. KT wants Higgy, Big Neck Higgins. Gotcha, KT. Gotcha. Gotcha, girl. Where are you?
I just realized I entered. Oh, no, I didn't.
No, you didn't. Because I disabled... hang on.
Cornpop slipped in.
Higgy, Big Neck Higgy. All right. Let's see how we go. Because I'm pretty sure we do have a Higgy, but I spelled it with a...
Yeah, we have.
With a Y.
I have it open here now in front of me. So, Higgy, yeah, it's Higgy. You wrong is the response.
She wants Higgy IE, so we'll give her that. But I've got to play this. I've got to play this out because if I move off this screen, only Jess Dawson, Britt Ketchell, Bessie Squad, Tracy Summers, and Corn Pope have typed it correctly. Nefarious with the exclamation mark. Nefarious with the exclamation mark at the front. Shelly babes, you're in. You got it. Shama Lily does it with a question mark. Nope, it's an exclamation mark. I thought mods were excluded. They are, Corn Pope. Oh, you're in it. Yeah, but see how it says you're a modder. Even if it turns you up, it'll roll it again. I think. I could be wrong. RC11, you're in. You in. Sorry, you're in, not you in. You're in. All right. Everyone's still struggling to get it right. Exclamation mark. Nefarious. Nefarious with an E. AJ, you're in. You're in. Type it differently, Mr. Jackson. Good on you, Tracy. All right, who else is going? Anyone else want in? You have 10 seconds left. 9, 8, 7, 6, 5, 4, 3, 2, 1. Game over. Choose a winner. AJ, you win. You win, AJ. So let me go find AJ. Where are you? Over here. Gotcha. Let me get AJ's link. Stick her into the Butterini. Have you got your command organized, AJ? Regulars, new regular. Oh my God, I've forgotten what KT's was. What was KT's again? Higgy. Something. What was KT's again? Jen. Higgy, big neck Higgy. Okay, I gotcha. Copy. All right. That is your command. Higgy IE. And the bot is going to reply, Big Neck Higgins. And that is for regulars. There we go. We got yours in there now. KT, you can test it if you like. Last game, hang on. Who won this game? Just gone. I've forgotten who it was already. Regulars. AJ. AJ, what's your bot command? New command, AJ. Did AJ type what hers was? Scroll. Not yet. Okay, AJ. Tell us what you want your command to be and how you want the bot to respond. Can I use Piggins? Yes, you can use Piggins. Yes, AJ. If you like. So JFK channel did a voice comparison of the Kevin that called into his show. Kevin from Southie. They thought it was Higgins. He said, but those were decorated dudes. Yes, it can be Piggins. Yes, it can. What reply would you like? Just not anything about teeth, right? We're not making fun of people's teeth. I'm on strike. I'm on camera strike until people start making fun of people's teeth. I did get a temporary replacement set of bridges, but I'm on camera strike until you make one. You want it to reply. What's a good reply for Piggins, Kev? She wants us to make it up.
Oh, Jesus. I was off making coffee there. Piggins.
Here, piggy. Oink.
Something about Weedwhacker, no? Was that Jen's name for him, or was that her name for herself? Or Karen's name? Sorry.
That was Karen's name for herself. Weedwhacker. Right. Yeah.
Lawnmower?
What's some funnies about how he's like just so bad at girl shit?
Brett Ketchell says grab ass.
Grab ass. Grab ass is good. Let's go with that one. Grab ass. Grab ass Piggins.
Decorated dudes, but I've heard that said as decorated dudes. I think somebody uses it as a username.
Decorated.
No, decorated isn't. Quack.
Oh, decorated dudes.
Yeah, it was to do with the whole.
Decorated dudes. There you go. Grab us piggins, decorated dudes. How's that? Whoops. Moderator. No regulator.
I love Corn Pope's enthusiasm.
There you go. Okay, AJ, you can type piggins now and it should reply to you. So, contrary to popular belief, here we go. Michelle's going off on a tangent. I don't think it actually was Higgy. I know how scandalous. I'm going against the masses. It sounds fake to me. Just saying, in my opinion, I'm on the same page as you, Michelle. I don't think it was him either. Well, Shelley babes, well. All right, let's edit that. Piggins, well. Hang on. Grab us. They're all good, aren't they?
Did we get a Proctor one at all? We didn't yet, no. Because I think he's on the stand Monday.
Well, grab us piggins and decorator dudes. There you go. You got to put the exclamation mark in front of it. See how it's on the screen here? With the exclamation mark. Piggins. Oh, you got it. She got it. All right. Last game. Oh, my God. I keep pressing the wrong tab. All right. Last game. Random number. This is pick a number between 1 and what, Kevy?
69.
1 and 69. Okay, guys. You got to pick a number between 1 and 69. The bot's got one in mind. If you guess it, you win. It's going to give you hints as to who's too high or too low, etc. Okay? So, here we go. 5, 4, 3, 2, 1, go. Guess the number. I'm going to tell you.
Jess
oh my God.
Me. Everybody's going for sick. I knew that would happen.
How the hell did you win? You're not supposed to be in the game. Kevin won. All right, stop.
That was supposed to be a joke.
Stop, everyone. Reset.
Let's see. Can I
okay,
pick
go again. Carol M, you are too low. Kevin, stop it. You're not allowed to play. Carol M, too low. Michelle, you need to get up here and smack Kevy for being naughty.
I was just trying to have fun there. I genuinely didn't think it would be this 69.
12 is too low. You didn't think it was going to be 69, and it was.
The whole idea of picking 69 was the joke element, you know. Anyway.
Everybody's too low. Okay, Bestie Squad is closest at 69. Tracy, you're close at 68. 64 is close, Carol. So, Jess Dawson, you win.
Yeah.
All right, let me go get Jess. Where's Jess? Jess Dawson. There you go.
They're still going.
I know it's blinking so fast I can't catch Jess and get her, buddy. I got her. I caught her. I got it.
I do listen to you, Michelle.
All right, Jess Dawson, you are now a bot regular. Tell me what your command is and what you like the bot to say in response. Jess, new command. Let's go, Jess. Are they still typing numbers? That's how far behind we are.
Oh, the delay is terrible today.
Yeah, it is a lot further. And I don't get any control over it. Like the server picks the delay, essentially. So, I think my headphones are going to die. Give me 1 sec.
No bother.
Oh, there we go. All right. Cool. This is cool. Yeah, okay, Jess, but tell us what you want the bot command to be. You're right.
I do, Michelle. Sometimes.
A road trip to Lang's house. Jess, what would you like your command to the bot to be, and what would you like the bot to respond from that command? Is this really how we do it in Massachusetts?
Yeah, we already have that.
We do.
I'll put it
We
up
do
there,
have
right?
that one. We do have that one, Jess. So have another go. We can play a couple more rounds if you guys are enjoying it. I'm happy to play another couple of rounds, but poor Kevy, it's nearly 5 in the
No, don't
morning.
be worried. I'm fucking wide awake.
Oh, good. For Bev, that's right. Thank you, Kev. Have another go, Jess. The real winners for everyone who guessed 69 with Kevin.
There's your buddy, Pet Goldfish.
Goldfish, how's it going? Can you refresh my memory? Will it still work if I change my name back? It's not under your name, it's under your account. So I'm not going to tell you what your account is because I don't want everybody to know.
People can find it out very easy anyway.
Yep. Are you a liar, Jen? Right. That's a response, but what's your command to trigger it? That's a good one. I will put that in.
I apologize. That was her phrase of the testimony. I apologize.
Are you a liar, Jan? And we can just make it liar if you like. How about that? Liar?
What? What does that stand for, Michelle? PACRAFO. Find out anyway.
I can't recall. I can't recall. All right, I'm going to just do it as liar. So you need to type ! liar to operate your command. Jess? All right. Should we play another game so we can have some more fun? Let's do another game. Let's go again with let's do another random number because that was fun. You lied to the feds, Jen?
We still have no. I can't believe we've no proctors.
We've no proctors.
None. We've 57. Nope. We've 57 on the list that I have, plus what's gone on tonight and the last night. So that must be another 10. So we have 60, nearly 70 of them, and not a single proctor.
Right.
Oh, sorry. Apologies. There's one.
Okay, so someone has to whoever wins the next round has to come up with a proctor one. All right. So Kevy's got a special request in because he's not allowed to play because he's naughty. Cornpo's playing because she likes the game, but you know what I'll do? I'll let mods play this time. So the number. Wiki balloon knot. That it's the number between 1 and 69. Okay, ready, set, go. Oh, I forgot to select mods can play. I said I was going to, and then I forgot to do it. I thought it was the next screen.
Whack job. See you next Tuesday. He's a whack job.
Cornpo, you win. No, you're in. Sorry, too low. Too low. Oh shit, it's going too fast for me. Holy shit. Tulo, Tracy, Tulo, Corn Pope, Tulo, everybody. Michelle, you're close. Besties, you're close. Jess Dawson, you're close. KT, too high. Carol M, close. Corn
So it's
Pope, close.
between 55 and 66.
Close, close. Is it getting there? Too low, AJ. Too low, perhaps the Steve. Too low, besties.
I'm laughing at Michelle here.
Too low, Michelle. Too low, besties. Corn Pope got it. Dun dun dun. You got it, Dale. You already won it. So I can't tell you what number you won on because you just keep typing them too many too fast. So
they're still
Corn
going
Pope. We'll just wait for them to see. Corn Pope's type like 10 more cents. I was totally cheating. How can you cheat? All right. So Corn Pope. Everyone's good. All right. What proctor? I'm pretty sure you're already in here, aren't you? Oh shit,
I thought
she's
she
not
got
in
one
here.
the other night.
Hang on. I thought she did too. Didn't she give it to
maybe
someone
she
else?
did, yeah,
I think
yeah,
she
yeah,
did.
yeah.
All right, wait. Corn Pope, I'm dying. Okay, it's your turn, Corn Pope. You're going in this time. You can't just give it away. You got to have a proctor one. New regular. Corn Pope.
Don't worry, lost in the, what is it? Michigan. We're going to play another one or two, I think.
Message already exists. Oh, she is in there. Where? Ah, right there. Yeah. Duh. Let's go, Corn Pope. New command. Give us a proctor one. Guess a proctor one, mate. Guess it. Guess it. I got 2 ads. Oh, Carol M missed the game for 2 ads. Arnie Babe, you have to say it. I said VJN. Proctor, you fired. Okay.
Yeah, that's a good
Deal. Proctor.
Get off my lawn.
You fired. All right. It's a regular. There you go. Spell AH for you. Just special for you. Whack job. No news yet. Pooper troctor. That's why I spelled it AH so we can so that we can have proctor as well. OR as well. So so there you go. Try proctor with AH. That way we reserved proctor for another funny one. Because we need a couple of proctors. We need to do some funny proctors. Mr. Proctor. So, you know that exam that you get from the rear end? Isn't that called being proctored? I can hear you.
Oh, can you? Sorry.
Vaping.
Mike's close.
It's a good thing you are. It's a good thing that you are, though, because I know you gave up smoking. So
yeah, it's night and day.
Well done. Well done. DMC for Proctor, don't come Monday. DCM, I think you meant, but I gotcha. Pin it on the girl, you've been proctored. That's what I reckon, KT. I'll give you another one, KT. Though. Let's do another game. Let's do one more game. One more giveaway. Any, meeny, miny, go. Which game do you want to play, Kevy? Last one.
Do I suppose the numbers one. Yeah.
Numbers again. All right. Next. Moderators are in. Next. Number between 1 and Would you like, Kev?
What number? Between 1 and 100.
And 100. Alrighty. Are you all ready? 5, 4, 3, 2, 1, go.
Yeah, I have 3 weeks done, Michelle. You're sorry, DCM.
Okay, too high, Jess, Corn Pope, too low, Michelle, too high, Papster Steve, too low. They're going too fast for me. Shelly Babes, too high. Hang on. Michelle, too low, too low. KT, you win again.
What was the number?
You win again. All right. No freaking idea, because it 57 actually. No.
57.
Yeah, 57. Or 99. I don't know which one. Because it triggers the next comment. She was set 57, so it must be 99. The number was 99. So there you go. Okay, KT, you get a proctor. You get a proctor exam. Go for it, KT. Which proctor would you like? I totally forgot which numbers I chose. Yeah, and I can't see them once that message pops up on the screen. It covers up your answers, so it's got a few flaws in it, this game. KT, you won, and you can choose anything you like. It doesn't have to be
proctor,
a proctor.
you've been proctored, so it's exclamation proctor, which I think we have we?
Right.
Yeah, we have that one.
I think we have, because the bot's answering her. So
just
proct,
PROCT. And then.
All right. Wait.
You've been proctored.
Wait. Come back, KT. Where are you? Fucking hell, I've lost you. Hang on, this guy's still catching up.
5th one down on the screen.
Yeah, I'm waiting for this other chat to catch up. Oh, I gotcha now. Yeah, because I can't get the channel ID from Restream. I've got to do it in the other chat.
I could be doing that for you.
So,
actually, now that I think of
it. Regulars. New regular. Add regular. Oh, you already got it. I already did add you. I forget who I've added. All right, KT wants. She wants proctor again.
Cornfolk loves wee woo.
We'll just do that. Proctor. And then what was it she wanted him to say?
You've been proctored.
You've been proctored.
Yeah, I need to get a CSV off you later on too, after this is over. I'll bait me own.
Peach. There we go. Yes, regular. Create. Yeah, we've done a couple of games since I did one, haven't we? Let me go find it for you. Let me get you all the CSV happening.
Oh, look at this. Michelle's getting nasty here.
But commands. Right. It'll take me a minute to set this up, so just give me 1 minute. Let's do that. Obviously I've got to clear all these commands out. It's page 1, page 2, copy. I'll give you all a link shortly. Just hang in there while I copy it all over. It'd be good if the bot just gives you like a download link, wouldn't it? Sidebar, page 3. Here we go.
You sending that to me, are you?
I'm going to send it to everybody. All right. Share. Copy link into the chat. Here you go, chatteroos. Grab a copy of that for all of the commands. Now, if it says regular, you can operate it. If it says everyone, you can operate it. But if it says moderator, then only the moderators can operate it. So they are marked in green. They're the ones marked in green. But there's a link for you all, to go and get a copy of it. Did you get it, Kevy? Did you get that link?
I did.
Good.
How did I get it as a CSV the last time? Or you sent it to me in Discord?
I sent it to you as a CSV in Discord, yes.
I need to figure this out again.
So just save the link. Just save the link, and then you can have it open for any live stream that you're on.
Where the hell did I put it though? Too many windows.
I got to work out if I can give you. Let me work out if I can give you access to the bot. I don't think I can, but.
Library. Bar commands. There you are. Right. I just bookmarked that. So, right.
Whoops. Whoops. No. Whoops. No. No. Stop it. Oh, no. I fucked up.
I'm sorry. I'm sorted. I'm all good, as they say.
Yeah, I was trying to work out if I can addly friggin' showed everything in my account.
Why can I not see the chat box now?
And I can't.
I've lost chat.
You've lost chat?
No, it's just on my screen, the way I have the screen split up. They're back.
All right. Everybody save that link. That's how you operate the bot. You can just copy out of the first cell and paste it in chat, and you'll always get it right. How's that? Manager. Here we go. Add a manager. Let me get Kev. Kev, type something in the chat for me so I can get you the easy way. Honk if you love Kevin. Thank you.
Thank you, Lon.
All right. I think I can give you access to the bot. Add Kevin.
How do I do that, though?
Enter the ID of the username you'd like to add as a manager. Status code not found. Come on, I just copied it straight from him. The ID. I've got to take the ID part out. How about that? Doop. Hang on. If I can't add you that way, how do I freaking add you?
Do I need to have access to your restream or anything? No.
No.
Yeah.
Kevin the Nefarious Leprechaun, but if you change it, no, that's not letting me have it either.
Do you want me channel ID?
I just tried your channel ID. It says the username or ID of the user you would like to add as a manager. I just tried your ID. Oh, I see. It gives you a user ID in the bot. Okay, let's do that. Here you go. I'm going to give you the bot link. You need to go in there and connect it to yourself, however.
Yes,
And
AJ.
then
Sorry,
in your
just answering AJ here. Yes, AJ, it only works on Ozzy's chat.
Only my chat, that's correct. That's the link. Go in there, get it going so that you can see, your dashboard. And tell me when you've got the dashboard up. It'll say it's not joined to anything because you're not running a live, but once you're in your dashboard, you can
Which
get
one?
me
What do I click here? Because all I've got is add to chat.
Down. Did you click the Nightbot TV?
I clicked that link and it brought me to like a home page, and the only option is about support our products, and then just add to chat.
Okay, see down the bottom where you are as a person. There's 3 dots beside it.
Oh, hold on now. Down the bottom. No. Hold on a second.
Let me share my screen so you can see what I'm talking about.
I'm sure this is fascinating for the chat.
I'm sure it is. See down here. Oh my!
No, I can't get into that. I can't. I've kind of been brought to their homepage, it's like a login or something.
Hang on.
And it's only the only option is give. Oh, hold on, dashboard. No.
See down the bottom how it says Aussie Insider, right down the bottom here.
No, it's not bringing me. It's not bringing me into your.
It's not meant. It's not meant to. It's your own Nightbot for your channel, but I need your user ID out of here.
But I don't. Can we do this off?
Sure.
Once the stream is over, because it's not doing what you're saying.
As soon as I can get you in there, as soon as I can get you into your own, we get the user ID. I can add you to this one as a manager. And then all of a sudden you've got access to everything and you can copy the IDs and do the extra work in the games. So
do I get a pay raise?
Do you get no pay rise? No, you've been naughty today. Well, Michelle gets the pay rise.
You could add another 20% to what I'm already getting.
20% of 0 is 0, dude. But we all love you, Kevy. Don't we, guys?
I know you do. I know you
do. All right, guys. So that's it. We're going to do this offline. So, Kevy, don't hang up and we'll get you in there somehow. Somehow we'll manage it.
That's what she said, huh?
That's what exactly. We might actually have to kick a live off on your side to connect the bot, get your user ID, turn the live off, and then put your user ID in here. We might have to do it that way. So if anyone's watching Kev's stream, we might end up live over there for 2 seconds.
It'll be the only thing ever posted to my channel in 10 years.
In 10 years, right. I don't even know if you can kick a live off over there because I think YouTube's got restrictions.
No, I had to set it up the other day for something to do with you, to accept your invitation or something on
right.
Studio.
Yeah.
So I had to.
We're all set. We are all set. Thank you, Nightbot. That's the perfect hooray. We're all set. Goodbye, everybody. And let me do an outro song for y'alls, because we enjoy the music over here. If you're not a music lover, now's a good time to switch off. So you've got the warning music coming shortly, as soon as I freaking find it. Except I just found an ad instead. Bloody hell. If I just let the ad play out, it won't happen during a song. So give me a sec. It's funny because I already did have the outro song set up, ready to go, and somehow I closed it. So Silly moi. Silly moi. Okay. We are over and out, boys. We'll talk to you next live stream. Bye.
Take care.
District attorney went off the rails. Innocent until proven guilty. Never came out of his mouth. That is outrageous. We are outraged. Before any trial has occurred, he announced the defendant's theory of the case is a desperate attempt to reassign guilt. That is outrageous. We are outraged. He provided a false notice of discovery, claiming he did not know. We now know that was a lie. That is outrageous. We are outraged. This court should be outraged. Everyone should be outraged. That is outrageous. We are outraged. District attorney went off the rails. Innocent until proven guilty. Never came out of his mouth. That is outrageous. We are outraged. He provided a false notice of discovery, claiming he did not know. We now know that was a lie. That is outrageous. We are outraged. This court should be outraged. Everyone should be outraged. That is outrageous. We are outraged. That is outrageous. We are outraged. This court should be outraged. Everyone should be outraged. Outraged. That is outrageous. We are outraged.
Bye, all.
And I will not be intimidated.
Oh, that didn't happen quick enough, did it? Nope. Oh well, duty happens. All right, let's get you sorted out on how to get Nightbot. Nightbot has to join your chat to get anything to happen before you're going to get this address down the bottom. So let me show it to you again. See down here?
Are we off air?
And then-
We are?
Yeah, we
Okay.
are.
All right. I'll close that window. Open up. And split my screen here so I can see what you're doing.